Please use the mic.
Serial number 6, my lord. I may be permitted to withdraw, my lord.
Which one, sir? Which one, serial number 6?
Petition is filed. Memo is filed seeking to withdraw the petition. Memo is taken on record. And the writ petition is dismissed as withdrawn. Yes, next.
Serial number 18, my lords. The writ petition has become infructuous, my lords. I may be permitted, may be dismissed as having become infructuous, my lords.
Suit is disposed of.
Please, my lords.
A memo is filed stating that the suit, that is OS number 338 of 2016, was dismissed to the trial court on 27/6/2024. And the petition has become infructuous. Memo is taken on record and dismissed as infructuous. 620.
18 minutes. Much obliged.
Your lordships kindly, may I make a mention for adjournment minutes? Serial number 20,
All.
please.
Page wise adjournment, page 1, serial number 1 to 3, list 1. Page 2, serial number 4. Page 3, serial number 7. 5 and 7. Page number 4, serial number 8 to 11. Page number 5, 12 to 14. Page number 6, 15 to 17. Page number 7, 19 to 22. Page number 8, 23 to 27. Page number 9, 28 to 31.
Lordships kindly, serial number 28. I appear for the respondent. Some inconvenience today, minutes. Any date next week.
Have you informed to the petition?
I'll inform him, minutes.
You have to inform that.
Minutes, I'll inform him immediately. Some inconvenience for my senior today, minutes. That's the only reason. I was not able to get him on the phone in the morning. I'll inform him as soon as the adjournment is granted.
The request of land council. If again he comes and says that.
No, minutes, I'll make sure.
Informed, again I'll post it to tomorrow.
Please.
At the request of land council for the respondent, list this matter on 4th of March.
Please. Grateful.
You look at it if interim order is there, extended.
There is no interim.
Page 10, serial number 32 to 35. Page 11, 36 to 42.
My lord, serial number 40, my lord. There is some inconvenience today, my lord. I am for the petitioner, my lord. May be taken.
Inform the respondent.
I'll inform, my lord. I'll inform the respondent.
When the cognate says you have to inform and mention, if everybody says I will inform, then it's difficult for the court. Don't worry. That's why I want you to look at, so that the advocates will not do it. No, the same thing the other advocate is saying. It's not I will. You have to inform and then mention.
I'll inform immediately, my lord.
That's what I'm saying. The moment they come and say that I'm not informed, then I'll post the matter tomorrow itself.
Please.
At the request of land council for the petitioner. Respondent or petitioner?
Petitioner, my lord.
Petitioner. List this matter on 12th of March.
Interim
The
order may be,
Interim order granted is extended till then.
please.
Page number 12, serial number 43 to 47.
Lord, serial number 47, Lord. I am for petitioner. I inform the other side, Lord.
Yes. When do you want?
Next week or any
This is matter on 1st of March. At the request
interim
of,
order is there.
Huh?
Interim
At
order.
the request of land council, the petition interim order earlier granted is extended till. Yes,
List number 2, serial number, page 1, serial number 1 and 2. Page 2, serial number 3. Page 3, serial number 5, 4 and 5. List
Okay.
1, Adjournment Matters, serial number 1. Sagar BB for petitioner. BB.
you can just put this side.
I appear for the first
time.
Ready?
The junction box. That way
You
it's
should
short.
come this side. It is on my face.
Yes.
You are for respondent one, no?
So in the-
On memo ಇದೆ.
It is obstructing I'm not able to see the advocates also because it's on my face.
That way it will come.
It's not coming clear.
No, it's only.
ಈ memo ಹಾಕ್ಬಿಟ್ಟು
If it is done, no, it's not a big deal.
Can you keep that one? Sit up.
Take this out.
Okay.
Yes.
Yes, my lord, the petitioner is, my lord, plaintiff in the court below. My lord, annexure A, my lord, page 21 is the plaint. Page 21, my lord.
Oh.
My lord, I filed a suit for declaration to declare that the decree obtained by respondent number 1 in OS 10,086 per 1990 is wide and consequently I sought for declaration by title. During pendency, my lord, the parties have amicably settled, my lord, the dispute and a compromise petition is filed as per Annexure D, page, my lord, 50, page 50.
Dated?
My lord, Annexure D, my lord, page 50. But however, my lord, the trial court, my lord, as per Annexure E, page 60, my lord, the compromise petition is rejected on the ground that it is opposed to public policy, my lord. However, both parties have, my lord, honored the terms and conditions of the, my lord, the compromise petition. The only thing is, my lord, at the time of executing as per the compromise, I had to execute, my lord, a sale deed in favor of respondent number 1. I have executed the sale deed also. At the time of executing the sale deed, respondent number 1 has agreed, my lord, to give 2 acres of land to me, my lord. That was not part and parcel of the earlier compromise application. So I have served a copy to my learned friend to go through it. I will report it, my lord, by way of, my lord, memo. If my learned friend agrees, my lord, it can be disposed today itself. Or if the learned friend wants to verify, my lord, let him verify and make
What
it.
is to be disposed of that I'm not able to understand?
Yes, my lord.
What is to be disposed of? What
Now,
is the order impugn?
Not now, since the parties have already amicably settled, the compromise petition is, the terms of is already, my lord, honored by both parties. Only thing is, there was a
What
oral
I
under.
don't able to understand is what is the cause of action for you to come to this court?
My lord, the compromise application filed was rejected.
So we have to look at it, whether it is legal
Yes,
or not.
rejected. But still not,
Otherwise, there is nothing to record by this court.
Yes,
Unless what is wrong with the order has to be seen, nothing else.
yes.
Yes.
That is, my lord, annexure, my lord, kindly see, my lord, annexure E, page 60.
Let's see.
Annexure E, page 60. The reason for rejecting the compromise petition is, my lord, on page 66. Page 66 from top 4th line.
Yes.
If the said compromise is permitted, then it is opposed to public policy because a person who suffers a decree has to
Let us
prefer an appeal
understand
and
that the relief that he sought in the suit is?
the relief, my lord, I sought relief in the suit is that to declare that the decree obtained by respondent number 1.
It is a plain.
Annexure A, my lord, page 21 is the plaint.
1 minute.
The,
Decree declaring that the judgment and decree obtained by the defendant
yes,
is null and void and to be rendered as nullity.
consequently, I sought for declaration also, my lord.
This is the prayer you sought.
Yes, declaration also.
And what is the compromise that is filed? Let us see.
Now, compromise petition, my lord, annexure D, page 50.
Huh.
In this compromise petition, the petitioner plaintiff agreed to execute a sale deed in favor of respondent number 1 in respect of survey number 212, measuring 5 acres 16 guntas. I have already executed, even though, my lord, the compromise petition is rejected. Afterwards, my lord, we have executed, my lord, the sale deed. Virtually, my lord, the terms and conditions of the compromise petitions are honored by both parties. However, my lord, at the time of executing a sale deed in favor of respondent number 1, R1 agreed that out of 5 acres 16 guntas, he has agreed to give up, my lord, 2 acres, which is not mentioned in the compromise petition. So, my lord, I want to report, my lord.
What? That is what precisely I'm saying.
Yes,
You did something voluntarily on for an
yes,
as a agreed or entered into between the parties.
yes,
How is it? How that issue has to be dealt with by the court? Court has nothing to do with that.
yes, my lord. But in view of,
you voluntarily did something. He voluntarily accepted something.
yes, my lord.
No, he is refusing something. Then you both of you deal with it independently.
Just
Or
I
does the
want to
court-
place, my lord, all these facts.
of the court, which is not enforceable.
Yes, my lord. Just I will file my memo that in view of the subsequently both parties have honored the, my lord, terms and conditions. The nothing survives, my lord, in the petition, my lord. Only thing is I want to file a memo, my lord. If my lord friend wants to file a memo, wants to read the memo, my lord, let him read and make his submission.
Yes.
Otherwise,
I'll go through the memo because what,
Is it to go, is it a reference?
reporting.
no, because what has happened, my lords, what I have stated in the compromise petition is something different. And he is claiming that the land will have to be returned to the petitioner.
This court will not record all those things at all.
Yes,
If you want to withdraw, withdraw. Because it will be doing something which we cannot do it directly and doing it indirectly. What the court can do is, if your parties have settled the matter according to the petitioner, counsel for the petitioner,
Yes.
and the petition is dismissed as withdrawn. I'll not record any of that because that's not the part of when there is nothing wrong with the order passed by the court. Will not record all this. So I can only, if you want, I can say it is stated that They've settled amicably and they're not pressing on this writ petition and dismissed as not pressed.
Consequently, my lord, suit also has to be.
That
Lord,
will not go into any of it. Please get instructions tomorrow.
Yes.
Next.
Till number 2. Surya Prakash for petitioner, Siddeshwar NK, the respondent.
Respondent.
I
Yes,
appear for petitioner, my lord.
yes.
The respondents herein entered into an agreement with the petitioner and another person agreeing to sell their lands in favor of the petitioner and another person. Being the respondents did not perform their contractual obligations. Petitioner filed a suit for specific performance. In the suit, the agreement of sale is marked as Exhibit P1. Your Lordship may kindly see, Exhibit P1 is produced by me at Annexure A. It is an agreement of sale. That is not in dispute, my lord. The only dispute is, according to the respondents, they have delivered the possession of the property to the petitioner. But the petitioner has not paid sufficient stamp duty on the agreement of sale. That question was decided by the court below, holding that I am bound to pay a sum of rupees 46 lakhs 55,200. The learned trial judge has come to the conclusion, as per Annexure H, that the stamp duty payable by me is at 8%. But according to me,
Please come to the order first, then we will
My
take
lords,
your submission.
I will go to the.
Yes.
Your Lordship may turn to page number 49.
Read.
49. In this case, during the evidence of PW1, a sale agreement dated 14/7/2005 was got marked as Exhibit P1. At the time of marking of document, the defendant has not raised any objection. When the case was posted for cross-examination of PW1, the defendant raised objection contending that the said document is insufficiently stamped document and filed an application under section 151 of CPC to impound the document and to collect the stamp duty and penalty. After hearing both the parties and by relying on the decision of Honorable High Court of Karnataka in ILR 2015 KAR 1984, Srimati Savitramma RPC versus Vijaya Bank and another, this court ordered for sending the original sale agreement Exhibit P1 to the Deputy Registrar Mysore to deal with the same, as per section 39 of the Stamp Act. However, by letter dated 3/11/2018, which has been received by this court on 6/2/2019, the district registrar has sent back the document to this court, stating that though the plaintiff was directed to pay duty and penalty of rupees so much, they have not paid the same and returned the original document before this court. Subsequently, the learned counsel for the plaintiff submitted that though it has been stated in the document that the possession has been delivered to the plaintiff under the said document, the possession has not been delivered and it can be made out from the written statement of the defendants and also the document produced in this case. He has contended that the plaintiff is not liable to pay stamp duty and penalty by considering the said document as a sale agreement with the delivery of possession. On the other hand, the learned counsel for the defendants argued that the contents of the sale agreement is clearly shows that the possession of the property has been delivered. For the purpose of calculation of stamp duty, the court has to look into the recitals of the document and it has to determine the stamp duty on the basis of the recitals found in the documents. The contention of the defendant that the recitals of the documents has been taken into consideration for determining the stamp duty has to be accepted. In Exhibit P1, it has been clearly stated that the possession of the property has been delivered under the said document. Therefore, as per Article 5E1 of if the agreement is relating to sale of immovable,
That, please
Ah.
come, as I've seen the order.
please, my lords.
Yes.
Now, I'm taking only one contention before your lordship. They have stated that I am required to pay at the rate of 8%. That is not found in the Stamp Act.
Please come to 5E, let's see. Article 5E,
Article
5E.
5E1. Yes, my lord.
Please
Possession of the property is delivered or it is agreed to be delivered before executing the conveyance. Same duty as a conveyance. Number 20, on the market value of the property. Market value of the property is not disputed.
What is the market value?
52 lakhs 90,000 was the market value at that time.
What is the stamp duty if it is a deed of considered as a deed of conveyance?
No, my lords, for conveyance, stamp duty is 5% plus 5% cess and 1% registration. Only 6.5.
Hmm.
But here, it is calculated at the rate of 8%. 8% nowhere it is found.
Yes.
My lord, your lordships kindly see.
According to me, the stamp duty payable by me is
Hmm.
26 lakhs 45,000. That I admit.
According to you, it is 6.5 of the market value.
Market. That is the total stamp duty it
Yes.
attracts when it is conveyed.
My lord,
Under
your
which provision it is 8%?
My lord, your lordships kindly see, my lord. Prior to this order, there was already an order by the my lord trial court as per Annexure G. Annexure G, for a moment, your lordships kindly see.
This, whatever is the order,
Yes,
whether it is legal or not is a question.
yes.
Now, what is the market, what is the stamp duty payable on this document? Please come to the Stamp Act
Yes,
and show the court.
yes.
Whatever it is, he'll pay.
My lord, yeah.
It appears, it is as on the deed of a conveyance. What is the stamp duty
10
payable?
times my lord
And then
penalty
I will
was
pay
my
the
lord
penalty.
imposed. Your lordships
Yeah,
kindly see. For a moment, Annexure G.
It
Yes,
would be like this.
Yes.
First of all, you have to determine what is the percentage. Thereafter, for impounding
Correct.
that, what is the penalty?
yes. Your lordships, for a moment, that is the reason I want to clarify that aspect. Your lordships kindly see Annexure G. My lord, this is the earlier order. My learned friend, my lord, he has not questioned this
earlier
order
order
in
I
the
have
present
produced.
writ petition. Kindly, for a moment, Annexure G, your lordships kindly see. There are two orders are passed by the my lord, trial court. Annexure G in page number 41. My lord, on my application, my lord, in pursuance of this Sumitrama's case, my lord, earlier, my lord, trial court passed an order. My lord, your lordships kindly see Annexure G. My lord, operative portion of the order is, my lord, in page number 46. My lord, IA5 filed by the defendant under section 51 of CPC is allowed in part. The sale agreement marked as exhibit P1 is impounded and exhibit P1 sale agreement shall be sent to the deputy registrar Mysore in original to deal with as per section 39 of the act. My lord,
Why this order again is passed by the court when
Lord,
that is the order?
that is I want to clarify. My lord, in spite of the order passed by the deputy commissioner of the the deputy registrar of the Stamp Act, my lord, the plaintiff has not paid that amount. My lord, the deputy registrar Mysore, my lord, he determined the my lord amount. Yeah, my lord, as per the order of the district registrar Mysore, but he imposed my lord penalty 10 times penalty. That is the reason, my lord, this order came to be passed. My lord, my learned friend, he has not questioned this order. But in pursuance of the Malad referred, the document referred to the Malad Deputy Commissioner for stamps. Malad, there is an already an order by the Malad authority. Malad, recent Supreme Court also says that
Yes.
Malad court has.
Why did you not pay as per the order passed by
My
the
lord.
deputy registrar?
My lord, I will come to that. My lord. The trial court judge, without discussing or without applying his mind as to the stamp duty, he has erred in passing the stamp duty. The same was sent to the deputy commissioner and he in turn returned it. He has not determined anything. So what I pray now,
Please look, come to page 46. Where did the judge determine the stamp duty?
your lordship may, before that, your lordship may kindly peruse page number 44,
Yes.
para number 9. This is an erroneous order. So once again,
They are not concerned. What is operating is the order impugned. What is the penultimate paragraph? in
your
the
lordship
order?
may kindly see, on the plain reading of the sale agreement exhibit P1, it clearly shows that the possession of the property has been delivered to the plaintiffs under the sale agreement. Therefore, the stamp duty is to be paid as a conveyance as provided under Article 20 of the Act on the market value of the property. As per the sale agreement, the market value of the property was 52,90,000. The sale agreement is dated 14/7/2005. Article number 20 of the Act provides for the payment of the stamp duty in respect of the
In
conveyance.
that order, 101 observations might have been there. But ultimately, what is the order? He has delegated it to the registrar to determine it.
Yes.
And when the registrar has determined it, then what is the remedy available to you?
My
And
submission-
the order impugned, even on that count also has to go, because whatever is determined by the registrar, you have to pay. If you don't pay,
No,
your
my
suit has to go.
I am bound to pay, but the registrar has to determine it properly.
If he has not determined properly, what is the remedy available to you as per the Stamp Act?
Stamp Act I have provided with an appeal.
You didn't go there. You didn't prefer that. And
I-
why should the court do this exercise again?
My humble submission is,
You only liberty that.
one
can be
one
granted to
liberty
you
your
is-
lordship may grant to me to question that, and to pay the stamp duty, a reasonable time may be granted.
No.
I will pay the stamp
You will pay the stamp duty
as determined by the court below already. Without prejudice to that, I may also be permitted to appeal before the appellate authority.
Let him do it.
Please,
Please come.
Third. in pursuance of the recent Supreme Court judgment, Malad,
That is,
recently,
that
Malad, instead of 10 times, twice, Malad,
That's
that
it. No, what it says is, as
Yes.
far as the court is concerned, court has no discretion.
yes,
Court has-
true, Malad, authority has jurisdiction.
Authority has.
Malad,
That's fine.
authority already passed an order. Malad, as
Has
against
a remedy of
I have
filing an
not
appeal against
gone
that.
in appeal, sir.
So let him pay as determined, and leaving it open for him to question that order.
Please,
By applying the Supreme Court judgment.
The agreed whether orders passed in.
Both annexure G and H.
no, he has not questioned annex.
Both the order.
No, Annexure G.
No, my
is
lord,
not
sorry, my
questioned.
lord, sorry,
You
my
are
lord.
kindly
I have-
see, my lord, in the.
I have stated about the annexure G, that's all.
Agreed with the orders passed in. I number. Or agreed with the orders passed on the admissibility of the document. Whereby the court had determined the stamp duty to be payable on the agreement of sale at rupees 52,90,000
No, on 52 lakhs.
has, the
46.
court has
46.
determined the stamp duty of rupees 4,23,200 and penalty by 10 times the stamp duty of rupees 42,32,000. In total, the plaintiff was directed to pay a sum of rupees 42,32,000
Plus.
4,23,200 altogether, an amount of rupees 46,55,200 was directed to be paid towards stamp duty and penalty. Agreed thereby, the plaintiff is before this court. The learned counsel appearing for the plaintiff submits that the suit is filed seeking specific performance of an agreement of sale dated
14/7.
14/7/2005. The earlier, it is submitted that the court had directed the petitioner to pay the stamp duty at 8% of the market value. And the land counsel for the petitioner submits that in the entire stamp act, there is, the 8% is nowhere mentioned. How the court has arrived at such a conclusion is not known. It is submitted that the percentage of stamp duty to be collected and the penalty as determined by the court is contrary to the provisions of the act and is not liable to pay. As such, the order impugned needs to be set aside. Next para, land counsel appearing for the respondent, defendant submits that in fact, on an IA filed by him, that is IA number 5, an order came to be passed by the court on 28th of May, 2018, and directed, and the matter was referred to the deputy registrar as per section 39 of the act. What is the provision 39 or the?
There is a determination of my lord.
Deputy Registrar now,
39.
Deputy Commissioner power to
39.
stamp
Deputy
impounding
Commissioner.
of the document.
And determine the stamp duty and penalty under section 39 of the act. Thereafter, he has determined the amount, and when the plaintiff and the defendant and the plaintiff has failed to pay the amount, thereafter this order came to be passed. Land counsel submits that under section 39, when once a deputy registrar has determined the stamp duty and penalty, the remedy available to the aggrieved party is provided, and where it is provided appeal.
power to revenue authority to refund penalty or excess duty in certain cases. That is section 44. (45A) is available to me, my lordship.
It refers to refund.
Undervalued.
And the undervaluation, if undervaluation is made, they can impound the document under 45A.
He submits that such an order passed by the deputy registrar is not questioned by the plaintiff. As such, the order impugned passed by the court holds good and no interference is called for. Next paragraph. Having heard the counsels on either side, there is a material on record. On an earlier IA, that is IA number 5 or 4. On IA number 5, when an order is passed by the court, referring the matter to the deputy registrar, the deputy registrar has passed an order. That order is not questioned, and thereafter this order impugned came to be passed. The court, came to be passed. The plaintiff ought to have, if he is aggrieved by the order passed by the deputy registrar, he ought to have questioned the same. But he has not taken any steps to question the said order. And now it is contended before this court that the percentage of stamp duty that is collected is not correct, is not that 8% he need not pay. And also raised several other grounds. In the considered opinion of this court, when the petitioner had not questioned the order that is passed by the deputy registrar, it is not open for him to raise any other grounds. Questioning the legality or otherwise of the order passed by the deputy registrar when a remedy is available to him. And during the course of arguments, land counsel for the petitioner submits that he'll pay if a reasonable time is granted to pay the stamp duty and penalty as determined by the court, He'll pay the money and the liberty may be given to him to question the order passed by the deputy registrar concerning the submission of the land council for the petitioner. This court do not find any reasons to interfere with the order impugned. Accordingly, this court is passing the following order. Number one, the petitioner, there are no ground, the plaintiff shall pay the amount of rupees 46,55,200 as determined by the court towards stamp duty and penalty within a period of
4 weeks.
within a period of 4 weeks from the date of receipt of the copy of the order, number one. Number two, the petitioner is at liberty to assign the order passed by the deputy registrar, so and so, within 4 weeks from the date of receipt of the copy of the order, accordingly disposed of.
That contention of delay, my lord, I may be, my lord, liberty to approve.
All other contentions with regard to the
There's
delay
inordinate delay, that is the reason,
delay and other
2018
things,
order.
it is open to the
No,
defendant.
no, immediately they retake.
Any of it, yes, it is open.
Please.
All contentions are open.
Please.
Sale number 3, Hemant Bharadwaj for petitioner.
I appear for the mother. Respondent mother.
What has
My-
happened on the?
Yes, my
But
lord,
after your lordship's order on the last occasion, on 9th of
may
Jan.
I-
zero interaction between the daughter
No,
and.
no, I want to show.
Can I
exact-
make my submission?
No, no, I would like to make my
The
submission.
court has asked
because-
me a question. I'm making my submission. My lord, I'm also placing an affidavit on record along with videos, my lord, of visitation that happened prior to 9/2 and every single visitation that's happened from 9/2 onwards. The daughter is again not looking at my face, not talking to me, not interacting with me. I've heard the copy of the affidavit.
And may I also file an affidavit of, from our side? May I just give a copy, madam?
But if your lordship permits me, I
Madam,
have the videos, my lord, if I could, my lord. Your lordships have observed on the last occasion that the child is very playful with the father. Except your lordship also made some observation about me not being physically close to her. Your lordship observed, my lord, the child is very, very playful with me.
in fact,
not
the
from-
lordship observed, sorry, let my
Yes.
friend.
No, thereafter, my lord, from the second weekend of January, she comes with a watch. Visitation is not extending beyond 40 minutes and there is no visitation at all. She comes, sits in the house, does not talk to anybody, looks at her watch, opens the door and leaves by herself. And the respondent is waiting on the same floor on my apartment floor. Very unfortunate, my lord. The child is being manipulated, my lord, and she's swinging like a pendulum. And the mother, my lord, does not realize how she's playing with the mind of the child. A child who's so happy with me and with my mother, who's playing with us, has completely cut us off from her life for the last 1 month. My lord, I have the video. If your lordship will kindly see those videos, my lord. May I, my lord, with your lordship's permission? May I take it there? Siddhant. Take that. No, let him.
Yes.
And if my friend could also show me, because we have just been served with the pen drive this morning.
Or else I'll take it up in the afternoon, let her also see, let them also come back. Instead of
Very well,
wasting time.
yes.
Yes.
Then may I just hand over my affidavit also? I have served them a copy already. Yesterday, since matter was not taken up yesterday.
Yes.
So 30 today, right?
Yes,
Yes, grateful. I'll be here at 2:30.
yes, next.
Grateful.
Sale number 4. Sale number 4. For Prasad. Petitioner, promote Prasad BS.
Until 18th September, this court has ordered both creditors to come together, come up with joint arrangement. Only mistake by party has done in 18th September, the passport issue went wrong. I sincerely apologize. I don't know what transferred, what went wrong. If the order I saw until 18th September, very proper order, very fair order. In fact, the court has observed that the mother has the custody of the child and it is the responsibility of the mother to ensure that the child is comfortable with the father. This court noticed the deteriorating relationship between the father and the son and said that no, you must.
No, that's why now we must have understood why the court was very not happy with,
Only one submission.
no. I will listen to both of-
Before that.
I will listen to both of you, don't like, let's have. let-
Deposit it in for, we try to deposit it in the registry said can't be done. I have
Yes.
no application because the document is absolutely safe, it's a custody of the court. What was the problem? I guess?
No, that too, the whole exercise was done not for her, but for this, but your client. But for this person, the court has done all the exercise. When the boy was reluctant, the court was making it sure that the father gets. And suddenly one fine day, you say that as if, no. Suddenly one fine day, it is placed before the court saying that the court is unnecessarily wasting the petitioner's time.
I saw the order and I wondered what went wrong. You know, before the 18 on
What went wrong, I'll tell you. What went wrong is, court has asked for the assets and liabilities, and the father was telling the court a petty story that would come out. That's the only reason went wrong.
yeah, before this, I have an interim order passed in 2022.
That's true.
What has happened, I tell my lord, what has happened?
And from 2022, he is the beneficiary before this court.
Entitled.
He's entitled, that's what I'm saying. Entitled to, but that's why court is not helping him.
He doesn't know favor.
Yes,
He
not
doesn't
she,
know favor. It's
not
a-
she. Now though, for example, the order,
We just go back to that issue. This is now a forgotten issue. I apologize, we are complying with the order, so that issue is over.
yes.
Now, what we stand before this court with in the circumstances, in these circumstances. Interim order passed in 2022, where the order was that the visitation rights will be available to the father and that the child will spend the weekends with the father. Both parties came before the Honorable Court in 2022 saying that that is insufficient. According to me, it is insufficient. According to the mother, it was too much. At that point of time, this court observed, keep aside your ego. There is a very specific order by this Honorable Court before another was there. Keep aside your egos. Don't use the child as a tool between the two of you. Behave yourselves. If the order specifically passed, it remained there. Nobody, this court also did not say anything much. She disobeyed the order in 2024. Therefore, I come before this Honorable Court and say, she stands in disobedience, kindly grant. Everything was going fine. Then it was before your lordship. Everything was going fine. Your lordship also observed that, look, you have the custody. Do not condition the child like this. The child is entitled to the affection of the father also. Do not do this. In my experience, my lord, may I just say this? I think the liberty because I know how your lordship is dealing with matter. What probably did not help is that earlier custody was at home, visitation was at home. For some reason, this court started ordering visitation rights at malls, planetariums, and resort.
Because, no, one minute, the reason why I tell you, the father was not interested to go to their house. And the boy, but the boy was reluctant. That is the factor which happens. He starts, the moment he looks at the father, he starts crying. He's crying. In between what has happened between 2024 and that days, he had undergone a surgery, something has happened. So these are all the things to be considered.
Now, whatever they say, these agenda, and the father, I mean, the custody, I'm in my lordship. Whatever my lordship said, I'm in my lordship, and let us work out the custody in accordance with whatever the law was. On 24th, in fact, my lord had said that parties should come up with a joint parenting plan. Let them suggest where your custody, let them suggest what the parenting plan. It is my right. Nobody does me a favor by this. This was my mistake. I apologize. What went wrong, I don't even know what. I apologize for this. Now the matter is of custody. I want custody of my son. That's all there is.
What is the impugned order? Let's go to the impugned order.
Before going on merits, my lord, may I make
Yes.
only one submission? In the earlier occasion, not only this mistake, in earlier occasion also, there is a Dishonorable High Court pass interim orders to expenses and all. And they are not at all considered, they are not at all obeyed that order.
That we'll consider. That
And
also-
health issue is concerned, my lord, health issue is concerned. And the health expenses also, they are not at all given single NP. And I will finish my.
Yes, please complete.
And the earlier occasion, my lord, this Honorable High Court, coordinate bench, my lord, with regard to the health issue, I have taken care of each and everything. And our operation expenses also, I incurred the entire expenses. They are not at all given any expenses. This Honorable High Court, my lord, this, both the parents has to taken care and they have to pass. Instead of giving the expenses, he filed a complaint against the
That I know.
the doctors.
That I- that already-
Nowadays, that hospital doctor says that, my lord, they are hesitate to give a treatment in these days. And also the very same mistake committed by the petitioner in the school also. He, without any order, without anything, I already paid entire amount of the entire year fees. He went to the school and deposited 50,000 rupees. On what purpose he deposited, we don't know. And he started issue in the school. Nowadays, my lord, in the school also there is an issue.
That we will consider,
that-
that will
that-
consider, because no, the custody with the mother, one point of contact would be the mother.
Yes.
That we will consider,
Uh,
yes.
And expenses also, my lord. This Honorable High Court say interim order is there, even though it's not complied. And
No, right from the day they are separated till now, he has not paid anything
he
to
is
the.
not single NP. 50,000 rupees he deposited the school, and in that school, my lord, so only 23,000 rupees receipt has been given to my party. Remaining we don't know. And he said that, my lord, he 50,000 deposited, and 30,000, my lord, as per your lordship direction, last occasion, my lord, expenses he has to all expenses. In 30,000, he transferred last 15 days back. He transferred, except that one, he has not at all
When they are
spent.
separated,
As now 20.
2020 to 2024, nothing.
No, educational expenses, day-to-day expenses, or the medical expenses, each and everything is taken care by the. And one more aspect, my lord, she's also working, and he filed a contempt petition, even though the trial court, before the trial court, child was present in the in the presence of a judge, he refused to go, and they went to the mediation center. And that the mediation center also, he was crying, and even each and everything noted in the order sheet. Even then, my lord, they insisted to preserve. They issued a arrest application for arrest, and the court directed. Even though she is working lady, she is losing her job because 4 cases. They put 5 cases because of this issue. She's losing her job. And even then, my lord, she's each and every day she's attending the court. As and when bring it to the knowledge of this Honorable High Court, High Court, my lord, your lordship pass an order not to precipitate the matter. And then, my lord, they are stopped that even though this interim order is there, they have filed an application before the trial court, present before the court. And on that day, I filed a memo saying that this Honorable High Court's order is there. And after that, my lord, next hearing date, they exempted. These are all the issues there, my lord. Their intention has to be looked into each and every interim orders. Now, the main matters, I will argue the matter.
That is one aspect.
I will argue the matter in main matters.
Which we'll consider while passing the order. Then what has to be, what are your submissions on the?
Main matters, I will argue. These are I am bringing the knowledge of.
He wants, there is nothing to argue. It is about how it has to go on.
Last occasion, senior counsel informed that informed that he will give some proposal. Till today, they are not at all given any proposal. Till today, they are not given. Because they have to give proposal. No, my lord.
Clearly, on this case, there has never been an application for Interim. She is earning, I am earning, we are both equally, financially, we are both more or less the same. She has never asked me for money. This is just a story being brought in the court. She has never asked me for money. I have never refused. There is not even an issue about money between the two of us. Both of us are very.
So somebody has to.
I filed a.
Somebody has to tell you that you should take care of your son. Nobody told you to ask for the custody.
Tell me to take care of my son either. I am ready and willing at any point of time if there is a financial issue. I have paid.
What if
I have
there is a
paid.
financial issue?
Very genuinely, that's the issue. Most of the time, these are issues of egos. Nothing else. He will not open up mouth and say, I want money. I don't know what are the expenses to be required. I know that my child is financially secure.
No, I can't hear both of you simultaneously.
Sir,
One
because
I
that,
saw the patience to hear to the other side also.
please.
Yes.
If there is an application of money, or if there is a requirement of money, I do not hesitate. I have, on my instructions, either because this was also the same submission made on the last occasion in chamber. I instructed the applicant record, I want to see what payments have been done, I want the whole person to know what has been done, what is it that he is doing. Same attitude. I have done this, I have done that, I told him the same thing. You do no favor. Whatever you have to do, you have to do. So you do no favor. These are all ego issues. If today also the complaint is that there is some financial burden, I have no hesitation. Absolutely, in the least, I have no hesitation. If it is for the child, I will spend whatever is in my capacity to do.
What is your capacity is the question.
Both of us have to file affidavit, neither of us have done. What I'm saying is, issue was on the passport that has been, that is over. Prior to that, this court has passed order.
No, that's why, Senior Counsel, I'll tell you like this. No, let your client say, what is that he is ready to spend for the child?
No, for a moment. Let us first look at the affidavit. And then
We'll also look at it, we'll also look at it. It is a question from the court.
Very good order saying, let us look at the order that has been issued, and it is a blatant disobedience by the mother. The order, my lord will see.
No, Mr. Senior Counsel,
1912 of 2022.
just now you said the father is ready to take care.
For the time being, my lord will be done. My lord will be done. There is no application for it. There is only an attempt at all points of time to pay it in a bad way. I refuse to succumb to that. I refuse to succumb to these games. This is a game that is being played. I was until now in disobedience of this honorable court in terms of the passport issue. I have caused myself of that disobedience. I stand before this court. Look at what this court has done that. I come before this honorable court and say, yes, I am in your lordship's hands. Let's come up with a joint parenting plan. Now, what is the story?
No, what is the order passed by the court on so and so date? Where is the complaint?
Yes, my lord. I will show.
And again, is that the writ, SLP is filed, SLP is dismissed, then
Yes.
where is the complaints?
Yes, my lord.
Where is that? Let's see the order.
As a 24,
Order dated 22/10/20.
I filed, DV Act I filed, because
22/10/2024. Please place before the court. Please place before the court in compliance with the orders of this court. Then we will see.
may I make only one submission, my lord. May I make only one submission, my lord, because
Yes,
The order was 18th September 2024.
yes.
Both parties shall place before their court the statement of assets and liabilities as per the law made on the tax court in the case of Relinquishment. Along with the bank statement right from the year 2020 till today.
Mr. Place.
yes, ma'am,
So senior counsel, you have questioned this order. You say that they are in non-compliance. You have questioned this order before the Supreme Court.
Why is it an issue that question? That doesn't matter. This is an order which I have to abide by. There is no doubt about it. There can be no two ways about it. Either the order is set aside or the order has to be complied. There can be no complaint about an order. This is the order. I have no choice. I have to comply. I may be happy, I may be unhappy. That is the least consequence.
When is its order passed?
18th September. Both
22/10.
parties have not complied.
I am asking you, Mr. Senior Counsel, why do you bother about them?
Very good.
I'm asking you, why did you not do it?
Very good. Then mother has been taking care of. Well, you see, what has gone wrong here is this, that whenever the issue then comes up saying, all right, now let us talk about custody, that issue is not being addressed. Why is that the issue here? Let us talk about the custody. My son is suffering. Earlier, until we approached the court, the child was happy with the father. There are photographs which are produced showing the happiness of the child with his grandparents and with the father. Over a period of time, unfortunately, that relationship has deteriorated and this court has noticed it. This court has said also.
I have to bring it, only thing is, I have to bring it to knowledge of this court, my lord. So only,
Has passed an order directing both the parties to place a statement of assets and liabilities before the court. The same was questioned before the Honorable Apex Court, and it appears that the Honorable Apex Court has dismissed the SLP. Even till now,
It's a
the
consent order.
parties have not filed the statement of assets. This matter on 5th of March. By the time the party shall place before the court the statement of assets and liabilities. Thereafter, order will become the next, as per the order passed by this court, the passport is surrendered before the court. Let it be with the custody of the registrar.
May I make only one submission, my lord. May I make only, may I make only one submission, my lord. They are submitting before this honorable court saying that I have not claimed any maintenance. In the DV Act, my lord, I filed in the year 2021. He's avoiding the service of notice, one or the other reason. He said, and this honorable high court passed an order. It's a consent order. It's a consent order also. He's disobeyed because he filed an application. That's the reason I have not produced any assets and liability.
Please produce.
Tomorrow itself, I'm ready to produce it because he filed it. And
Yes.
Let us look at the issue of custody. Since none of us the petitioner has not taken stand, let us look at the issue of custody.
Let that be, we'll pass a final order on that.
Cell number
next
5.
date,
It's
Next
on
five,
4th
three.
of March,
5th of March.
much.
5th of March, yeah.
5th of March. Cell number 5, Arun Govind Raj for petitioner. Sai Guru. Krishnan.
For the
respondent, my lord, List. Yes.
my lord, I pray that the matter may be passed over. Senior counsel is engaged with another argument before another court. My lord. Much obliged.
It passed out matter.
Much obliged.
Yes, next.
Cell number 6, disport. Cell number 7. Narendra S for petitioner.
Respondent, please, madam. And in the cost title, please, madam, my name was not shown properly. My name is A.G. Nagraj, but it has,
You're here now. We'll record it.
plus, anyway,
Huh? What is that?
my name is correctly shown in the card.
Correct. Now, are you going to
Please,
argue or
please.
not?
Please.
We'll record it in the order.
Yes, please.
Yes. Where is it? Page number? Impugned order is in Kannada. Then what were you doing? You have asked 101 times adjournments. You didn't tell me tell the court that the order is in Kannada. And how are you expecting the court to know that? That's very unfortunate, Mr. Counsel. How many times a matter got adjourned? The list this matter in the same caption of dismissal and post on 11th of March. And by the time the petitioner shall file the translated copy of the impugned order, the registry is directed to print the name of the counsel for the respondent as, write it on the paper.
A.G. Nagraj, please.
Cell number 8.
Yes.
Cell number 8. Nanda Reddy PN for petitioner.
Appear.
Yes.
This is with regard to the levy of stamp duty.
That's what I asked you, which provision?
That is article, the judge referred to Article 2, Article 1, Schedule 1. At page 22 of the ink page. But this sum and substance, just I will submit that. The
So now we look at the provision, then
Yes.
we can go further.
Yes. No, document is compromise agreement. They we filed a private complaint under section 138 Negotiable Instruments Act, for which he filed a compromise agreement he has entered into to see that criminal case is closed. Since that was not happened,
Proceedings he filed there.
he has not filed anywhere. He wanted to file there, and he created a compromise agreement. That is now money transfer or something like that. Therefore, I mean, thereafter, my lord, I filed suit also. Suit also was pending. In the suit, my lord, I produced and marked. Thereafter, my lord, compromise was entered into. In the compromise, there is no reference to that, my lord, compromise agreement.
No, which is sought to be now,
Compromise agreement.
please come back to the facts.
Yes.
Come back to the facts and the order appeal, where is it?
Order is, my lord, at page 29. Both sides counsels are present. They filed compromise petition under R23 Rule 3 of setting aside their claims. The plaintiff and defendant settled their claim for rupees 9,50,000.
This is not the basis for the compromise.
There is no basis. There is no reference to that, my lord. The plaintiff and defendant so and so. He further agreed to pay the same with interest so and so. The plaintiff agreed to withdraw the cease in a criminal case before the principal civil judge and JMFC Chalkere pertaining to the check number so and so. The terms of compromise petition recorded. Both parties agreed and signed to the same voluntarily. Hence, the interest of justice.
That is what I was asking you. This is an order that is passed before you entering into a compromise. You have entered into a compromise, and that compromise is now the order I'm looking at is 22.
No, earlier before this my lord, order was passed to my lord, to send the my lord document for registrar, my lord, page 22.
No, this order has culminated into that a main order. Is it not?
Compromise petition was filed on.
Where is that decree, compromise decree?
Yes, page 31, annexure E. But of course, this is in Kannada last.
Hmm?
Kannada, it is there, my lord, I can last. There is no reference to that.
Where is the compromise memo?
Compromise memo, annexure. That is also in Kannada, my lord. Page C, annexure C, my lord, page 16.
Release this matter from dismissal. Release this matter on 12th of March. Yes, next.
Cell number 9 for orders matter. Muniappa for petitioner,
Appearing for the petitioner's matter.
3 times unsolved. Unclaimed for part 7.
Steps to be taken in respect of unserved R10, 3 times notice unserved with the postal shera in respect of notice in respect of, as per the postal shera, notice in respect of R7 is returned with the postal shera unclaimed, demonstrated deemed service of notice. In respect of respondent number 10, the petition shall come up with an application for substituted service within 2 weeks, or else the petition shall stand dismissed without further reference to the court. Next.
Cell number 10, M. Shiva Prakash for petitioner,
Petitioner, my lord.
V. Vijay Shekhar Gowda.
3 times notice has been served, my lord.
Substituted service, 2 weeks,
Application is ready, my lord.
already filed.
No, my lord, ready, my lord. I will file in.
Then day after,
My lord.
shall I take it up day after?
No, my lord. I will file it in the register, my lord.
That's what I'm saying. You
Please.
file it, I'll post it day after tomorrow.
Please,
The
Well,
council
Monday,
submits are
Monday.
already there, fine, huh?
Kindly have it on Monday, my lord. Day after.
They have, will have it on Friday. They have already filed an application for the substituted service of notice on respondent number, on the unserved respondent number 1. List this matter on Friday. Yes, next 11.
Cell number 11. 11,
Steps
Rajendra.
shall be shaken for issuance of notice to respondents R1B and R4 within 2 weeks, or else within a week, or else the petition shall stand dismissed in respect of R1B and R14. Next 12.
Cell number 12, Gopal for petitioner.
I am counsel for the petitioner side, my lordship. In this petition copy, left out the defendant serial number 12. In the cast title, please kindly permit the 3 days time. complaints for the office objection.
Upon petition is granted 3 days time to comply with the office objections, or else the petition shall stand dismissed without further reference to the court. Next,
Cell number 30.
Much obliged, my lord.
A. Madhusudan Rao.
in which case? Interim order earlier granted is extended till then. 13.
13.
Much obliged. my lord.
My lords, steps taken, my lords.
already
Needful done.
taken. It is submitted, the needful is done, post after service of notice. Next,
Cell number 14.
Petitioner
Masala
is-
Petsi.
They have filed an application for dismissal of the application filed by the respondent side.
what application they filed?
They have filed an application before the trial court for impleading the one party, which is required for the decision to be taken in the original suit proceedings.
Representation for the respondents. Counsel of the petition is present. Any interim order?
Yes, your lords.
Interim order earlier granted is extended. This is matter on 25th of March. Yes,
Cell number 15.
13, my lords, interim order.
look at it, 13 also, interim order is there extended. 15,
Cell number 15. 15. Rhoda Reddy. 14 only now it is ordered. Cell number 15.
that order is in 14. They're granted time. Yes, 15.
Rhoda Reddy. Rhoda Veena Shetty for petitioner.
Issue third time notice to R3. The notice in respect of R6 and R9 returned as unclaimed amounts to deemed service of notice. The petitioner shall pay the process for issuance of notice to R3 and objections raised on IA number 1 and to 1 of 24 and 2 of 24 shall be complied with within 2 weeks, or else the petition shall stand dismissed.
Cell number 16. Harish Bandari, T for petitioner.
Are enjoying interim order, my lordship, from 4 years. Only upon, my lordship, the rejection of a recall order, my lordship. Here the petitioner, my lordship, is in habit of filing recall applications. When the recall application is allowed earlier, my lordships, she remained absent. Then again, my lordships filed a recall application. Upon that, my lordship's trial court, by giving the same reasons, my lord, dismissed.
Retirement filed by some.
Earlier advocate, my lords. Now I have filed NOC wakalat.
It is memo by R1.
Yes, my lordships.
No representation for the petitioner, counsel for the respondent is present. List this matter for dismissal tomorrow.
Obliged.
Cell number
17.
17. 17.
Appearing on behalf of the petitioners, my lord.
No reason
There's an objection raised.
for the respondents. The office objections shall be, the office objection shall be rectified within a week. And any interim order?
My lords, the objection is raised with regard
that
to,
only?
yes, please, my
You have
lords.
an interim order?
No, my lords.
Now, list this matter on 8th of April. Yes.
Please, my lords.
Cell number 18 disposed. Cell number 19. Cell number 19. Moment advocate. For
My
petitioner.
lord, may I seek for 2 weeks to rectify the objection?
Why?
It's on the Wakalatnama, my lord. The respondent is in Delhi and I will also have to seek the
When
NOC
did you file your wakalat?
21, my lords.
And you want 2 weeks in 25?
My lord, just to secure,
A week's time is granted for complying with the office objections. Yes.
Cell number 20.
Any, look at it, if interim order is there, 20,
20. Kiran G for petitioner.
even for this also, again, years together, things will go on. Same objection the next also. Same, a week's time.
For the respondent number 3 and 4.
Yes, list it on.
My lord,
April.
I want you to, the delivery of possession has been taken place. That writ petition is not maintained,
Sir, Mike.
not maintained by me.
We'll see when
Seven.
something, yes.
Cell number
21.
21. 21. Cell number 21. Raghunath
Steps in respect of R1 and R2 shall be taken within a period of 1 week from today. And the office objections on IA number 1 of 20 shall be complied with. And also the amended cost title shall be filed within 1 week. Or else, if the process is not paid, the petition shall stand dismissed against R1 and R2 without further reference to the court. Yes, next.
Cell number 22. Kevin Nasiman for petitioner. Dispensation memo in respect of R2.
A memo is filed seeking dispensation of notice to R1, R2 and R3. Same is dispensed with at the risk of appellant. In respect of R2 and R3.
R2 and 3 only dispensation.
Oh, R2 and R3 only they are filed. List is matter tomorrow.
Serial number
I have some inconvenience in serial number 22 tomorrow. Could it be day after tomorrow
Day
or
after
on
tomorrow.
Friday if this
Day after tomorrow. 23.
Friday, can I request for Friday?
Yes, Friday.
Friday.
Very well.
Yes. Next 23.
Sole petitioner died, ma'am.
23,
In which case?
Sole petition, 23.
23.
Petitioner died.
Petitioner died.
When he died.
He died on 21/3/2020, 31/3/2021.
What are you doing from till now?
There is, thing is, he has,
Now the
power-
writ petition is abated. Dismiss has abated.
Yes.
21 he died. Even till 2024, nothing has been taken. I can understand respondent. But maybe you're not aware.
but, my thing is, order
A
39.
week's time is granted for taking steps in respect of the deceased petitioner or else.
I have filed, ma'am.
They have.
Where is that?
I have filed IA. Three application has been filed.
Any objections by them?
No objection is filed.
IA number 1 of 20, 1 of 25 is filed to condone the delay of 993 days in filing the application to bring the LRs on record. LRs of the petitioner, sole petitioner.
Sole petition.
Sole petitioner on record. IA number 2 of 25 is filed, setting aside the abutment. And IA number 3 of 25 is filed to bring the LRs on record. No objections were filed by the respondent. Considering the reasons stated in the accompanying affidavit, the delay of 993 days is condoned. IA number 2 of 25 is allowed by setting aside the abutment. And consequently, IA number 3 of 25 is allowed, and so and so are brought on record as LRs of the sole petitioner. The petitioner shall carry out the amendment in the cost item within 1 week
Please,
and file the amended cost item.
please.
24. Rachita Rashmi for petitioner.
Appearing for the petitioner, my lord, kindly pray for short accommodation. Matter may be taken up tomorrow, my lord. Senior counsel is appearing in the matter. He is not in town today, my lord. We have filed our objections and an IA for recall, and it's not been put up today, my lord.
What is recall of the order after the disposal?
Consent order.
Huh?
Consent order. The Honorable Supreme Court has directed them to comply with the order. My lord, may I file this memo? The Honorable Supreme Court, while transferring the petition, my lord, her transfer petition was allowed before the Honorable Supreme Court. The Honorable Supreme Court passed a specific observation that the transfer will not have any bearing on the consent order passed by this Honorable Court. At page number 2, my lord, para number 6. While transferring, may I read, my lord? We make it clear that this transfer order will have no bearing on the consent terms recorded by the Karnataka High Court. Para 6. While transferring. So this,
So wait to get that. Page number?
page number 2, my lord, internal page 2. The Honorable Supreme Court, the first document, my lord,
The
the trans-
petitioner wife has filed the present petition.
next page, my lord, para 6. While transferring, we make it clear that this transfer order will have no bearing on the consent terms recorded by the Karnataka High Court.
The last occasion I said, the client shall be present on the, virtually, I would like to.
We have not received any instructions from her, my lord.
Then what you can do?
Just 1 day time, my lord, may be taken up tomorrow.
Well, may make
If
this
she
request.
has any difficulties, court will understand.
Yes, my lord.
And without even coming to the court and without.
We
even-
haven't received any instructions. We'll seek instructions today itself. Matter may be taken up
So If
tomorrow.
you're not receiving instruction, then don't appear further.
They have filed objections, my lord. They filed objections with her affidavit.
Yes, my lord, but with this regard, we haven't received any instructions
How
about.
can you not, when you're appearing before the court has given a specific direction that she should appear online, why she has not?
It may be taken up tomorrow, my lord. We'll instruct her
Just
to be
tomorrow,
present.
tell her, this is
Yes,
not the
ma'am.
way.
So may I make one other request, madam, if it appeals to the court, instead of troubling your lordships tomorrow, my lord, in another criminal petition between the same parties, a coordinate bench has directed, my lord, her to comply with your lordship's order. And this weekend, my lord, I'm supposed to go to Gwalior to meet my son. Let her comply, my lord, the matter could be
No,
taken.
it is like this. There is an order by this court. I have
No,
not interfered. No, it is open for you, whatever to do. Again, the court will not tell some other on their application. I'll not clarify your rights or what has already been observed by
Absolutely.
the
No,
court.
look, what I've sought in this application I have filed is for modification to permit me, instead of her coming to Bangalore, I'll go pick up my son and come to Bangalore to not enable my parents to have.
It may be taken up tomorrow, my lord. Senior
Very well.
counsel's up. Much obliged.
Still number 25. Arun Govinda, shop petitioner. Tamenan.
What are these modifications? No,
No,
I'll be,
no, ma'am.
without having the roster, I'll
No,
be
my lord, it's a
having
very
the passing and
simple,
orders again and again.
No, my lord, it's a very simple clarification, my lord.
Uh,
My lord, in the first matter, my lord, your lordship had permitted the petitioner to take the children out of the Bangalore for a period of 2 weeks. Once in a while. And should compensate the visitation rights.
that's order dated 22nd July 2020.
Yes, my lord. But so
Uh.
in the subsequent writ petition, my lord, your lordship has permitted the father to have the children visitation.
There is that,
Well, that is next matter, my lord. In that matter, my lord, your lordship
that also. Next 26.
26.
Number 20.
In that, the visitation rights has been given to the father on his birthday and children's birthday, and also on all festivals. My lord, after this order, my lord, intentionally she travels to out of Bangalore on Deepavali day, which she did not give the children.
So what is the modification you want?
I am seeking that at least on the festivals day, she should not travel.
Not my
That
father.
cannot be compensated, my lord. That's the.
From tomorrow, we'll have a hotline. On every order passed by the court.
Correct, my lord.
The advocates.
My lord, I can understand.
So that on the hotline, you will be keep on sending your request and the court will be
No,
modifying.
no, the matter has been, my lord, now the.
We have settled the matter.
The
Pursuant to
matter has been
lordship's
almost
direction, my lord,
settled.
your lordship's
Now,
referred the matter to
they are-
mediation.
What is that?
Your lordship's referred the matter to mediation to learned senior advocate Ms. Sushila. Lord, agreement is finalized. We are not signing the agreement because of these two applications.
But they are, my lord, they are strictly obeying the, so far
No,
visitation
please-
rights.
Please understand. When you want to settle the matter, the same thing you can put forth before the before that senior counsel who has been conciliating the.
Yes,
matter.
my lord, the parties are, they have agreed to obey the orders of this honorable court in respect of the visitation rights. With regard to the visitation rights, they are not
Until
discussing.
You're entering into your final settlement. Whatever order you
My
want
lord,
from.
they are
this
not
court,
agreeing for that. That is the reason why I moved this application. Otherwise, I would not moved. My lord, there are two more clarifications in the second order, my lord. My lord, your lordship has the passed an order. My lord, in summer vacation, 2 weeks, my lord. But in the same order, my lord, your lordship has said that 40% of the vacation. My lord, the summer vacation will be about, my lord, for 2 months. My lord, at least 1 week more, my lord, which I am requesting. At least for first month, 2 weeks, and the second month, at least 1 week may be granted.
No.
Your lordship said.
No,
no,
1 minute. Let's go to this 25th September order.
Yes.
25th September order.
Yes, madam.
So now please come to the page number 6.
6, my lord, 7th, my
Yes.
lord,
So as far as 1 is concerned, you have no problem.
1 is no problem. 1, 2, 3 is no problem.
4 is the problem.
4 is the problem.
Let's see.
My lord, on the birthdays of the children as well as on the birthdays of the petitioner father, the petitioner father can have the visitation rights 10 to 12 noon. If it falls on holiday. If the school is working on those days, the petitioner father can take the children at 4 p.m. and drop them back by 6 p.m. The same timings have to be followed on all the important festivals.
We have
Now, my only submission is that, my lord, on those days, she should not travel with the children. Because it cannot be, if on Diwali day or Ganesha festival day, if she takes away the children, my lord, even if there has been the visitation is compensated, my lord, on the festival days, my lord.
If both of you are together, if she has to go somewhere, she'll take the children and go.
That would have
You
been.
just can't be, this kind of unnecessarily there, like, you're meddling with your happiness with all this.
We are both from Bihar.
That's the client.
We are both.
Understand this?
We are both from Bihar. He wanted Shankranti, my lord. He took on Shankranti. I said, please take him. Take the children and go. Shankranti.
My lord, the next, my lord, 5. When it comes to the vacation, my lord, the petitioner father can have 40% of the vacation. My lord, in the summer vacation for the first 2 weeks, the father can exercise visitation between 10 a.m. to 4 p.m.
When it comes to the vacation, the father can have 40% of the vacation.
Yes, my lord.
According to you, how much it should be?
My lord, at least 1 week more, that's all, my lord.
It will become 46% then.
No, not 6%. My lord, 60 days will be the holidays. My lord, this 2 weeks means only 10 days has been given to me.
40% of 100%. What is 40%? For
Okay.
example, it is 60 days.
Yes, my lord.
40% is
It will be 20 days.
24 days.
Yes, my lord.
It should be 30 days.
No, I'm requesting only 1 week, another it will be only 15 days.
60 days, you
Yes,
are
ma'am.
having 24 days.
No, my lord, not 24 days, only 2 weeks. 2 weeks, that too, Monday to Friday, 5 days.
Where did I mention that?
My lord, it's there, my lord. The father can pick up the children at 10 a.m. and
Summer
drop them.
vacation for the first.
He can exercise the
No,
visitation like
that
this.
day, that was the arrangement. Whether to, whether it is 40% or otherwise, in the open court, they were there, both of them were there.
Yes.
When they said, first week, second week, which part of it, and asking you people,
Yes,
I
ma'am.
pass this order.
Yes, my lord, correct, my lord, that, only that clarification.
First 2 weeks, the father can exercise visitation.
Yes, my lord.
The father can children at St. Honor. He can exercise will like this from Monday to
Monday to
Friday for
Friday.
the
That will,
first 2 weeks.
yes, only for 10 days it will be, my lord.
Hmm.
And then, my lord, after that, my lord, after 2 weeks, my lord, I have another 4, 5, 6 weeks, my lord. 6 weeks regular visitation has to be given. Now, because in the winter vacation, my lord, 2 weeks was the holiday for the children. My lord, I was given 4 days in the first initial this thing.
Mr. Govindra,
And
why
thereafter, regular visitation has been
No,
denied.
it is an arrangement made by the court.
Yes.
Now you are entering into a compromise. Why not happily, comfortably, which is good for both the parties?
Lord, I'm giving visitation more than what your lordship support because children now are comfortable with the father, my lord. Again, I'm grateful to my lord. Initially, my client was reluctant, but now the children are very comfortable. We are giving more than what visitation has been awarded by this court. But what my learned friend was now saying is, your lordship were very specific while passing the order. 3-year-old children, summer vacation you take 2 weeks for now, and your lordship have also said in the order, once they turn 5 years old, both of you can move the court for enhancement.
So till 5 years, I said. I
Correct,
will
it's
not
only
file
till
any
5 years.
application For this court, I undertook that I will not.
This
file.
arrangement is only till 5 years. After 5 years, he has
Is that once all these disputes are resolved,
So-
I think both the mother and father becomes unemployed. So that what they wants to keep it live and keep themselves engaged in something or the other.
Can you see paragraph number 9, your lordship's order? Petitioner father shall not move any application till the children are 5 years old, as the court had taken into consideration all aspects.
I'm not-
Which
that's
means
the
after
reason
5 years, my
I'm
lord, he's entitled to whatever
No,
modification.
Let us just try to understand what exact modification is asking. Now, what he says is,
Yes.
it's not 30%, 40%. No, for example, summer vacation. Summer vacation will be for how many days?
2
60
months.
days, 2 months.
2 months.
2 months. 2 months is 60 days.
Yes.
Court has granted in the 60 days, only 2 weeks. That is 14 days.
For
is
summer, 2
granted.
weeks,
10
other
days.
vacations, 40%.
No. So 60, that is 14 days is granted.
Yes.
No, 14 days, 10 days, Monday to Friday.
Monday to Friday, then court has granted 10 days.
Yes.
Then,
My lord,
that is one aspect which you
yes,
are
my
asking.
yes, my lord. Second, my lord, after remaining vacation, my lord, the regular visitation has to be given. The other 4 weeks on Saturday and whatever the district, my lord, that she is not giving.
Which means I shouldn't travel.
Uh,
Which means I shouldn't travel with the children. I have to be in Bangalore so that every weekend father
I'm
can
not saying
visit.
that, my lord, if she can't give that,
So what is the usual usual visitation?
Well, usual visitation Saturday from 10 to 2.
10 to?
10 to 2 every Saturday.
So why can't it be like this? No, on every Saturday,
Yes.
usual visitation is between 10 to 2.
Yes.
So whenever you're traveling, compensate that day, that one day that between 10 to 2 on some other day.
During vacation or regularly, because we're
During vacation, I'm referring.
very
Vacation, for example, you travel on
If
for
I go-
5 days,
yes.
10 days. So in that 10 days, he gets 2 days, I suppose.
yes, ma'am.
The 2 days, you compensate some
Very-
other day.
Very.
So that is one.
Yes, ma'am.
This is two else. And this is the last modification. That also I'll make clear.
Yes, ma'am. And there is one more this thing, my lord. Now, my lord, whenever the father cannot exercise the visitation rights, regular visitation rights, my lord, she is asking him to take the children on the weekdays every 2 hours. Well, it will be very impossible for the father to come for 2 hours for every day, weekdays and come. But my request is that, my lord, that compensation, my lord, 10 to, Saturdays 10 to 4 is there. My lord, on that compensation, my lord, 2 hours may be extended in that and it can be compensated.
Instead of taking it some other.
Yes, ma'am.
My lord, what happens is this. My lord, there are days we have given even for 8 hours. My lord, there are sometimes, my lord, whenever I miss visitation, I make sure that I compensate on a Saturday or on a Sunday. When he misses visit, my lord, now he travels 2-3 weeks at a stretch. He says, give me on Saturday and Sunday to compensate on Saturday and Sunday. I get no time with the children. Children also get no free time.
Saturday, Sunday.
He's insisting on Saturday, Sunday.
One Saturday, for example, he misses on something, that duration, you give him on Saturdays. So that what will happen is in Bangalore, one has to travel from one end of the city to the other end, but the 2 hours, that itself.
Well, 2 hours, we'll extend by 2 hours and then compensate on Saturdays.
By extending it by 2
2
hours,
hours.
one Saturday.
Yes.
It should have been
Till it's compensated.
That's well done before the mediator.
My lord, that's what, my
You
lord.
want to trouble the
My
court.
lord, I told
trouble
them, my lord,
yourself.
but before the mediation, they are not ready to discuss all this.
I'm sorry.
This is one.
Yes,
Then
ma'am.
That is all. Only 2 things they've asked.
what is in the first order? This is in the second order we are looking at.
Yes, madam. First
Order.
order, she has been permitted to take the children, but that's why I'm not, no problem. Only thing my request is that she should not travel on the birthdays and the festival days.
We'll not say festivals,
Birthdays.
we'll say birthdays.
Children's birthdays and father's birthday.
Festival, not the town, as a matter of fact, on every festival, I don't think anybody will be
Not at
traveling.
all.
On and off it happens, let it happen.
Let there
Let
be
it
an-
not be, huh?
Let there be an observation, that's all.
And I'll also write that these kind of applications will not be entertained. What is the first matter?
Till number 25.
24, where is the file? This is the one,
This is the one.
WP 18967 of, in both orders, WP 18967 of 20, disposed of on the same day.
No, madam.
Different date.
Different dates.
WP, then independent orders, WP number 18967 of 2024. This court has disposed of the writ petition
On 22/7/2020.
on 22/7/2024.
See, yes, filed a memo.
Where is that? Where is that in this order? This order dated,
Paragraph 8, my lord, is what my lord said.
Paragraph 8, my lord.
directed the mother to the extent possible, she did not take the children out of Bangalore beyond 2 weeks. If such situation in advance, the same shall be to
Compensation.
the father.
Yes,
It is appropriate to mention that it cannot be on regular basis. So now what has to be clarified in
next
this
sentence.
order is,
Next sentence, as undertaken by the mother, whenever she's out of Bangalore, she'd
Bangalore
compensate the vacation.
so the registration immediately after coming back, and the mother should see that the registration happens on regular basis. This court in the said order has observed that as undertaken by the mother, whenever she is out of Bangalore, she should compensate the registration immediately after coming back, and mother should see that the registration happens on regular basis, and it shall be the responsibility of the mother. Now, the present application, the matter is placed before this court, seeking modification of the order, where it is submitted with the land council appearing for the father that whenever he could not exercise the registration, she is insisting the father to have it on some other day.
When I miss, I'm giving on weekends.
My lord.
It's some, when because of the inconvenience or lapses on the part of the mother, if the registration he could not exercise, that she's compensating it on the weekends. But when it comes to the lapses or for any other reason, if the father could not turn up for the visitation, she's asking him to exercise the visitation on a weekday. And it is very difficult for the father to travel for 2 hours. It's very difficult for the father to travel on a weekday for just 2 hours. It is submitted that the order may be modified, wherein the mother may be directed to compensate the visitation by extending the time on the weekdays itself.
On the weekends.
Weekends itself.
Regular visitation.
In addition to the By 2 hours, by 2 hours.
Still it is compensated.
Till it is compensated. Learned counsel appearing for the mother submits that, in fact, to the extent possible, the mother is cooperating and cooperating with the father, considering the same. The order dated so-and-so is modified at para number 8. Look at it. As undertaken by the mother till the end, inverted commas, this paragraph of the order is modified as whenever either the father or the mother is out of Bangalore and they're not able to exercise the visitation on the weekends, that should be compensated by giving another two hours time in the weekends, and accordingly, it should be compensated. Then the next one, WP number.
But 2 hours still it is completed.
Huh?
2 hours still it is compensated.
Giving it.
2 hours extra.
2 hours extra.
Till it is
Till it is compensated. This is next one. Next, this court by order dated 25th of September 2024 had disposed of the writ petition. And in this order only I have referred, and the parties were directed to appear before the senior counsel, Srimati Sushila. And it is submitted that now the parties are, the matter is, they're appearing before the mediator and the matter is likely to be settled. It is submitted that, it is submitted by the learned counsel appearing for the father that on every birthday, he has granted the visitation on the birthday as well as
Festivals.
birthdays of the children as well as the birthdays of the father. The visitation between 10 AM to 12 noon. And if the school is working on those days, the father can take the children at 4 PM and drop them back at 6 PM. And this should also be followed on all the important festivals. Now it is a grievance of the father that the mother is traveling on all the festivals.
Now on Diwali she has gone the first.
Traveled on Diwali festival. And on birthdays, what happened?
No, the birthday is not yet completed. It's only
So vaccination, and there should be a direction that she shall not travel on the festivals. And the birthday of the father and the children. Other is, and when it comes to the
vacation.
vacation, the children are having 2 months vacation, that's 60 days. And the court has granted him 10 days. And the remaining days, the remaining days of the summer vacation, the father is not having the visitation. Hence, the father may be granted a week more of visitation, and also is asking a week more on the winter vacation, on the summer vacation, and also
And the regular visitation.
and also a regular visitation during the summer vacation.
Remaining summer.
In the remaining period, in the remaining period of vacation. Learned counsel for the respondent mother submits that in spite of, as the matter is pending before the mediator and the matter is coming to a settlement at this stage, all these applications are moved when the mother is very accommodative. Next para, considering the submissions on behalf of both the parties, the order dated so-and-so is modified. The clause number 4 of the order is modified as below. In addition to the earlier, the clause number 4, it is added as, within inverted commas, the mother shall not travel on the birthdays of the father as well as on the birthdays of the children. That I'll not clarify about the festivals.
My lord, that they should not take the advantage, my lord, then there is no clarification and travel and all.
To the extent possible, on the festival days, the mother shall remain in Bangalore. Next, coming to clause number 6. In addition to the, what is mentioned in clause number 6, it is added, it is added to clause 6 as inverted commas. The father can exert during the summer vacation. During the summer vacation, he is having the visitation for 10 days. And for the remaining visitation, he can exercise the regular visitation, that is between 4 to
10 to 4 minutes.
that is 10 to 2, the regular visitation between 10 to 2 on Saturdays. No, that's what I said, remaining period on 10 to, on Saturdays. On Saturdays. On Saturdays. If the mother, if the mother is traveling during the vacation, that shall be compensated. In addition to the on other Saturdays, in addition to the time granted, that is the court, that is 10 to 2.
10 to
It will be another 2 hours, and that's how it shall be compensated in the next. What is that?
My lord, according to my instructions, my lord, everything has been paid and the memo of calculations has been already filed before the family. If it's not paid, my lord, I'll.
It is also, it is like what you people are asking and what the order the court is passing. How can, when it disposed of
My lord.
matter without an application, how can there
Yes,
be an
ma'am.
order like this? It is submitted by the land council, then under what it will go in this order? They is seeking a modification of the order.
Yes.
There is no application. Even if I add, it doesn't look, it is not correct. What you can do is, if it is not done, you also come up with a modification petition.
Yes. My lord,
But please see to
my lord,
that.
according
It
to my,
doesn't come
yes,
with a
my lord.
modification
No, my
petition.
lord.
But definitely I'll ensure in the next modification petition, I will delete all these.
Yes. My lord, my lord, in summer vacation, my lord, another 5 days, my lord, at least 15 days. It'll be
Yes,
too less,
Mr.
my lord.
Govindraj,
No, I'm sorry.
60 days is having, what
My
you
lord,
do?
No, this is the Arab camp story.
That is what in all these matrimonial matters, things are happening.
Bill number
Yes.
27, SV but for petitioner. Jagdishwar NR.
What happened in this matter in the earlier? DP.
No. I remember what has happened. What I said was, either you have, like, if both of you are agreeable, we'll pass an order, or else we'll pass an order on the merits of it. That's it.
In the last occasion, they are offered 14,500 rupees. Now my client has ready to sell the property to the early petitioner for 15,000 rupees, 500 rupees, 15,500 rupees. She
And
has-
no
Yes,
discussion
she
on
has
this. If you are agreeable,
find out a-
15,500 will pass an order, or else on merits I'll pass. Because let it not go on like this from 2018. You put it to your client.
ಅವರೇ ಇಟ್ಕೊಳ್ಳೋದಾದ್ರೆ ಇಟ್ಕೊಳ್ಳಿ. We have no objection. If they are paid the 15,500 rupees, buyers also there.
Yes, tomorrow. Yes, tomorrow.
Tomorrow,
It is
day after tomorrow, my lord.
Day after tomorrow. Even that also you want to negotiate.
Tomorrow I have got some.
Day after to list this matter, day after tomorrow, land council for the respondent submits that their clients are ready to sell their share of the
Tomorrow,
property.
tomorrow, tomorrow, 5th, Allah? 5th, tomorrow.
Please.
Want to sell their share of the property to the petitioner at rupees 15,500. What is that square, what?
Square feet. Per
Square feet, per square feet, and comes for the petition, submits that, he'll come up with instructions, this is matter tomorrow.
Number 28,
Acha.
done, 29. Cell number 29.
I appear for the respondent, my
No,
lord.
for petition.
Respondent on record had passed away, my lord. I undertake to file wakalat, my lords.
Advocate for respondent passed away.
Yes, my lords. Advocate who's on record right now had passed away.
Give your name, so and so submits that. The advocate for the respondent is no more, and she has instructions to file wakalat. This is matter on 10th of March. Any interim order? Yes.
Cell number 30.
Yes.
Cell number 30. Chandranath Tariga K for petitioner, Ramesh Chandra.
File is, what about, are you ready?
I'm ready, but
pass.
then pass over better. Just. I'm
What do you
ready.
want?
Next week.
This is matter on 4th of March, at the request of Land Council for the respondent, the petitioner. Yes, next 31.
Number 31, Madhusudan MN for petitioner.
No representation on behalf of either of the party. This is matter on 29th of April.
Cell number 32. 32, Ramesh Kumar.
Respondent number 5, I think.
Yes.
D.R. Anantram for respondent.
Yes. You're the plaintiff or the defendant? Implement. What is the suit for? No, you're not.
4 and 7. Your defendants before the trial court, they actually got the 350. They had filed a counsel that we also do have a right to partition. So the mark is put for that. Defendants is that you are there, randomly they will not have to pay. They have to say that they should be dismissed for not other reasons. Let's not be just before that, even if you want to withdraw, please hopefully remains on top.
Please come to the order.
As plaintiffs, 4 and 5 by name Venkatappa, defendant number 3, Madesh, son of.
Order.
Order implemented at my lord, page 27, my lords. I'll read this, my lord. The counsel with defendant number 3 and 5 filed IA 1 Rule 10 to permit them to transpose as plaintiffs number 4 and 5. In support of the IA, they filed affidavits in that in the present suit, the defendant number 3 are also claiming share over the property, suit shell property, and the plaintiff is colluding with the defendants, and they will allow the suit to be dismissed for non-prosecution. And in order to avoid multiple proceedings, they pray to permit them, transpose them as plaintiffs number 4 and 5. I have heard the both sides and perused the material records. This is a suit for relief of partition and separate possession. As per the defendant number 3 and 5, they are also having right to claims in the suit shell property. In a suit for
What do you say that you should be
transpose as
a-
plaintiffs?
For what?
Because they are also joint family members.
No, you can be as a defendant also.
Otherwise, also,
Why should it be done? There should be a reason to transpose you as a plaintiff.
the reasons assigned is that the plaintiff had filed a suit for whatever reasons.
You are apprehending that they may not contest it. That can't be.
I'll just make out from the records. I'll just make out not. The suit for partition. Plaintiff become partisan defendants be a plaintiff, one and the same.
The
That's, my lord,
situation
that's,
arise for that.
that's exactly,
To
my lord.
transpose you as a
Yes.
plaintiff. Where is it, what you say?
I'll just, my lord, I'll just,
What you say?
this is the order, my lord, which I'm
Will
reading.
allow the suit to be dismissed for non-prosecution.
That's exactly, they're not contesting the matter.
Counterclaim will still be alive.
That's exactly, my lord, my apprehension, I just point out, let me, 2 minutes, my lord.
Initially, your apprehension from 2018, the suit is stayed.
Yes, my lord, that stayed. Because,
Then what is that you have benefited now?
no, my lord, if at all, in the event of also they don't prosecute, not my claim, counterclaim would survive for consideration.
Correct.
That is what exactly my priority is.
Why should you assume, sir? Court will not pass orders on assumption.
I do understand. It's not that assumption, my lord. I just point out from the order sheet. They're not prosecuting the suit. I'll just, my lord, point out that from the order sheet, my lord. Permit me to, my lord, proceed, read this to,
I've read this.
please,
entire order.
then I would just not that point out this, my lord. I've just given this. Paragraph 2 and 4 of my lord, application and affidavit, that is page 21. I've just given out what are the reasons are there, my lords. Paragraph 2, my lords, page 21.
Yes.
I do swear that during pendency of this suit, item number so and so and so, acquired by National Highways Authorities, Bangalore, fixed the compensation to the above said so and so. When such being the case, plaintiffs have colluded with the defendants and got compromised the matter without our consent and knowledge. It is very pertinent to note that defendants 1, 2, 4, 6, and 17 have also obtained signatures of plaintiff and filing the application to withdraw the fixed amount, compensation amount in favor of the defendants and the plaintiffs. We are also one of the co-partners and we are entitled for 1/3 share in suit properties, and that is suit for partition, all the co-partners. This is the application which I have said. A portion of land has been acquired now. Amount is lying before the court for disbursement. Not in the event of if they not withdraw this amount. But we will stand nowhere.
You don't have to be transported as a plaintiff.
I do concede, my lord, I am just, my lord, agree with what my lords now say, opinions that. These situations, what would arise thereafter, lords?
But you can't, your application can't be entertained. Court was right. Please come.
I'll just read this, my lord. I'll just note this, my lord. I'll just read one, my lord. I would rather see it as, my lord, the findings, incorrect findings. I'll just point out, my lord, then please, then it is not necessary for transposing on the plaintiff and he is at liberty to claim right as defendant also. Only on the ground that defendant 3 and 4 also claiming share of the property, they need not be transposed as plaintiff. Defendant can be transposed as plaintiff when the plaintiff failed to prosecute. Lord, if they fail, suit get dismissed, then I stand nowhere.
The counterclaim is there.
No, in fact, I did make, my lord, an incorrect statement. I just point out. It is, this is the application which I filed it. 1 Rule 10, I just made a wrong, in fact, incorrect statement there. 1 Rule 10, 2 is rejected. This one, I made a wrong, incorrect statement now. This is the application, my lords. I did not make a counterclaim. I'm sorry, my lord. It is an application under order 1 Rule 10(2) of CPC, transposing them. In fact, I did make a incorrect statement.
You can do it the day that day comes.
We don't know when, my lord, if ultimately suit dismissed.
Like that, why you don't know? You don't go to the court.
If we do go, my lord.
Every paper has to be served on the
Yes,
other
it
side.
is.
You will know.
It is.
You can't anticipate something and do it. Please
I
come.
just see, kindly see this finding of the Honorable Trial Court. I just.
Ultimately, whatever are the observations, ultimately the result is correct.
Honorable Trial Court says that you may, in the event they prosecute. Then I have to file again another suit for partition. Then that would hurdle will be there definitely, my lord. I'll just point out that.
When they want to withdraw, then at that time you make a.
The defendant with such approach, with such record that in the event of the withdrawing, I can transpose that with that liberty, my lords.
Yes, what do you say?
Please. Lord, as your lordship rightly observed, there must be a substantial reason for transfer that is the law settled on the point by the apex court itself. And though, of course, the provision of law invoked is not proper, nevertheless, I am not standing on the technicalities, as your lordships would kindly appreciate. The learned trial judge has rightly held that there are no grounds made at all. As my learned friend read the affidavit also, it does not make out any ground. The apprehending that the suit may not be prosecuted is no ground at all. What is the substantial injustice?
What he says is,
please,
that stage comes when you don't want to pursue the matter at that
not me,
point
my
of
lord,
time.
not me. I am a purchaser. It is there. Please, I understand.
Whoever it is.
Please.
The plaintiff. Then
Please.
at that point of time, he can file an
No,
application.
if truly that right he already has, and
That observation will.
truly, my lord, that right he already has, my lord. That is the law on the point with the apex. Please.
I number 6 is 5 under order 10, order 1 Rule 10(2) of the CPC, by defendant number 3 and 5 to transpose him, the defendant as plaintiff number 4 and 5 by order dated, what is the order date?
Next year, Lord. 9, 34 conservative notes.
37?
30th of July,
July
2018.
2016.
It appears 7.
30th of July, 2018.
37, 2000, by order
Yes.
impugned dated 37, 2018, the court had dismissed the application. It is a case of the defendant that he shall be permitted to be transposed as plaintiff number 4 and 5. It is stated that during the pendency of the case, the item number 1 is acquired by the National Highways Authority and fixed a compensation amount. And such being the case, the plaintiffs have colluded with the defendants and got compromised the matter without our consent and knowledge. And it is very pertinent that the defendant number 1, 2, 4, 6, and 7 have also obtained signatures of the plaintiffs and filing the application to withdraw the fixed compensation amount in favor of other defendants and plaintiffs. The defendants are also the co-partners and are entitled for 1/3 share in the suit scheduled properties, and that the co-partners either can be plaintiffs or the defendants, and they can be transposed to any position in view of the common interest and rights involved in the subject matter. As the defendants, as the plaintiffs are not pursuing the claim, and if they withdraw if the suit is dismissed for non-prosecution, the defendants who have the interest in the property would be affected, their interest would be affected. As such, they may be transposed as plaintiff and defendant. The court, by order impugned, had dismissed the application, stating that only on the apprehension of the defendant number 3 and 5, that the plaintiff will allow the suit to be dismissed for non-prosecution. The defendants need not be transposed as plaintiffs. If the defendant number 3 and 5 are permitted to transpose as plaintiffs at this stage, then it would lead to unnecessary confusion. Moreover, they can claim their share or the suit scheduled property as a defendant also. As far under those circumstances, the court felt that it do not find any reasons to permit the defendant number 3 and 5 to transpose as plaintiff number 4 and 5. Next para. Then counsel appearing for the defendant submits that which part of the observation you are referring to?
Lord, the court, Honorable Trial Court says that, third paragraph, my lord, the defendant can be transposed as plaintiff when the plaintiff failed to prosecute the case effectively.
The court observes that the defendant can be transposed as plaintiff and the plaintiff failed to prosecute the case effectively. The counsel submits that when such is the finding of the court and when the different plaintiffs are not prosecuting the matter, the court ought to have permitted the petition defendant number 4 and 5 to be transposed as plaintiffs. It is submitted that the court, without considering all these aspects, are dismissed the application. And if in the event if the suit is dismissed for non-prosecution, they'll be put to the defendants will be put to loss and hardship. Then counsel appearing for the defendant submits that the application under order 1 rule 10(2) is not maintainable. And further, the court had rightly considered that on an apprehension of the defendant, they cannot be transposed as the plaintiffs unless and until substantial cause is shown, or the plaintiff he submits that if the plaintiff fails to prosecute the matter, as this the suit being a suit for partition, the defendant's claim can also be addressed by the court, can be considered by the court, and there is no the reasons made out either from their application, the necessity to transpose them as a plaintiff, and the court had rightly dismissed the application. Next, but having heard the counsels on either side, peruse the material on record. The reason why the defendant number 2, 4, and 5 wants to transpose themselves as plaintiffs is that their apprehension is that the plaintiff may, if they do not prosecute the matter, it may be dismissed for non-prosecution. And then the amount that is lying in respect of suit item number 1 property where the compensation amount is granted, if the same may be withdrawn. On either of these grounds, the court cannot pass an order transposing the plaintiff, defendant as a plaintiff. As rightly observed by the court, these are all the apprehensions of the defendant. If he wants the amount, the compensation amount not to be dispersed, there is a remedy available to him. The remedy is not to transpose him as a plaintiff, and he cannot on his apprehensions. The court cannot come to the conclusion that what would happen in the event if the plaintiff do not pursue the matter. In a suit for partition, always the court can decide the rights of the parties and even the rights as being a party suit for partition. Defendant's right to the property will always be decided by the court. In that view of the matter, this court do not find any reason to interfere with the well-considered order passed by the court. Accordingly, the court is passing the following order. The order impugned, the writ petition is disposed of. This for giving liberty to the petitioner to. Actually, that is not required.
Not-
You will have
I just one
It's a matter of
apprehension.
right, my lord.
the writ petition is disposed of, observing that the defendant will have always the defendant's right to seek for partition is inherent, and you can and no observation needs to be made in that regard.
Please.
I'm sorry to interrupt, Lord. Since this application has now been petition dismissed and the order of the trial court is confirmed, in the event, Lord, if they want to tomorrow withdraw this, then I have to object it. I have to come on record as a plaintiff. This order would certainly, my lord.
That's what I said.
No, this order would certainly come in, my lord, against
I
us.
said I made an observation.
observation.
That is implicit. That is, you have a right every time. Court also observed that.
Right for partition, I am agreeable with.
Said, I think you have not read the
No,
order.
I'm not.
The court said you have a right provided the defendant, the plaintiff is not prosecuting, and these are all your apprehensions.
Please.
33, Vaishali Hegde for petitioner, SCGP for respondent.
Lord, appearing for petitioner. Lords, I seek for short accommodation in this matter.
You have an interim order,
Please,
will not grant.
my lords, day after tomorrow, my lords.
Let's look at look at the proceeding sheet, give it to me.
My lord, senior counsel appears in this matter.
No, we can't help it, let the senior counsel appear, he should come. At request of learned counsel, the petition is this matter on 4-2. Term order earlier granted is extended. The request of learned counsel, the petition, this is matter on 25th of February.
Bless me.
Yes, sorry,
Case
sir.
number 34, A.M. Rajanna Shetty, K.S. Nagareddy for respondent.
And for petitioner, I was a plaintiff in case, Your Honor. We had filed a
Who appears for the respondents?
K.S. Nagareddy.
last week, advocate had appeared in third matter, Your Honor. He had sought time asking if that, in these 5 cases we had filed, in 2 cases amendment has been allowed. So he had requested for,
Appeared? The government advocate appeared in this matter.
BD advocate appeared, Your Honor.
No, I'm not appearing in this
Not
case.
Nagadi, Your Honor. One more advocate is there on that.
I think BDA.
BDA.
BDA. There's a separate panel is for BDA.
What is his name? The council appeared on the day for the BDA. How many councils are there for BDA?
PDA, there are so many list of.
Did he
One
file?
NR Girisha had appeared, Your Honor.
What is him?
NR Girisha in the second matter, he
Let
had
us
appeared.
say his name is there, N.R. Girisha.
Yes, Your Honor.
There is no representation on behalf of the respondent, BDA. On the last occasion, Mr. N.R. Girisha appeared before this court and sought time. List this matter as part heard, day after tomorrow.
Then number 35. Nagaraj Asi for petitioner, P. Mahesh.
I appear for this.
Lords, this matter, I'm challenging the order passed in the execution proceedings, my lord. I've been sentenced to undergo a detention for 6 months in civil prison. Lords, I've challenged that order, my lords. Brief facts, my lords. The respondent filed a suit seeking permanent injunction. The suit was decreed. It is confirmed in appeal also. I'm not disputing that said fact, my lords. My only contention, my lords, before your lordships, my lords, is that the relevant provision, my lords, providing for execution of injunction order, my lords, is order 21, rule 32.
No. Their case is that you have violated the injunction order.
Yes.
What is the injunction?
Permanent injunction, my lords, not to interfere with their peaceful possession of the scheduled
What
property.
is your case on that? Let's forget about the provision.
Lords, their case is, my lords, on.
Simple, before you go on
Please,
the merits
please,
of it,
please.
let's not go into the technicalities. You have suffered a decree.
Please.
You are bound to
Honor,
obey the orders of
please,
the
please,
court.
please,
If you are not obeying it,
please,
and if you say that I am obeying, then it's altogether different case.
please.
If you say that I am disobeying the order.
That is not at all my case.
Law is different.
Please.
I cannot be sent, then that this court will not.
I
consider
board on,
that
my
as-
lords.
that
I
as-
board on. That is not at all my case. That it is not at all my case that I don't want to obey, that I'm not obeying. Even before the executing court, my lords, I filed an objection saying that I was using the road adjacent to the scheduled property, not the scheduled property, and that at the relevant.
What is the adjudication done by the court on that?
Lords, that is where I wanted to point out the lacuna in the
Where is impugned order?
impugned order is at annexure A, my lords. I may be
What the court to do, it is in Kannada.
I may be permitted to pass on the translated copy, my lords. I just. Yeah, I should file it by way of a memo.
Have you given him? Let's go to the reasoning part.
Lordship may kindly find the reason at para 6, my lords. Page. Sorry, my lords, not paginated. May I read it, my lords? The decree holder had filed OS number so and so against the judgment debtor seeking an order of permanent injunction. In the said case, the decree has been passed in favor of the decree holder. The defendants have filed regular appeal so and so challenging the said decree, and the said appeal has also been rejected. Even though the defendants have been disturbing the peaceful possession and enjoyment of the suit scheduled property by the plaintiff, in this regard, defendants had lodged a police complaint at Terkanambi police station, and the police have refused the case, stating that the matter is civil in nature and to resolve the case before the honorable court. Therefore, the plaintiff has filed the above application. The judgment debtor has contended that the judgment debtors were going to Kerala to work as coolies, and they came to know about the decree being passed in the favor of plaintiff in OS number so and so and so. That the judgment debtors have filed so and so appeal before the Chamarajanagar senior civil judge, and said appeal is pending. The judgment debtors never attempted to interfere with the peaceful possession of the scheduled property by the plaintiff. The judgment debtors are not the owners of the scheduled property. The judgment debtors are using the shoot scheduled property as the road and gully. The decree holders have lodged the police complaint in so and so police station only with an intention to harass the judgment debtors.
No, what is the evidence before the court?
Please, my lords, I shall point out, my lord.
The judgment debtor is violating the decree. What is the observation of the?
My lordship, an evidence has been
Where is the
adduced.
recording of that?
My
the
lordship,
order?
it will continue, my lordship.
I've read the
Para-
complete order.
First of all, my
Para-
lordship, this order is an appealable order. This order passed by the land execution court is, my lordship. It is an appealable order. He has to file a miscellaneous appeal if at all he is aggrieved. My lordship, kindly see. I have produced the documents
This
at paragraph
appeal
8.
is admitted.
Yes.
This petition is admitted.
No, it is not, my lordship. It is in B group.
It has been granted.
It is in B group, my lordship. My lordship, rule is not issued. The rule is not yet issued. In paragraph 8, my lordship, the decree holder have produced 3 documents before the honorable court to substantiate the above facts. After examining the said documents, the certified copy of the judgment in OS number so and so and
3 documents, how would they show these interference, the disobedience of the decree?
my lordship, in the evidence, my lordship, in the evidence, he admits that he is making use this my property for the
Ingress and egress.
no, my lordship, not ingress. He has placed some flower plants in my land, and also he has admitted interference, my lordship. He denied.
The order is very silent about how it has come. Simply says,
That's not my lordship.
Exhibit A, P1, P2, P3, what are exhibit P1, P2?
Yes, ma'am.
What has to write?
That
It is written, exhibit
that
P1,
explanation is there, my lordship.
exhibit P1 was the judgment of the suit.
Okay.
Exhibit P2 was the
Wait,
police
see
complaint.
there. What
Police-
is suit P1?
police
Exhibit
complaint.
P2 is NCR.
Yes, my lord.
Exhibit P3 then, if you give a complaint, that itself is sufficient.
My lordship, kindly see, in the evidence, my lordship, I have-
Understand.
I
Where
have-
did where did the court mention about the evidence?
my lordship,
My lords, may I make
1 minute.
after ninth paragraph,
Yes, I've read it.
after through examination of the oral evidence and the documents filed by the decree holder, the objection filed by the judgment data, the nature of objection itself, my lordship, he denies my title or the property,
Oh, what you have.
my possession or my title.
Please
for the
understand
property.
this, when the court passes an order,
Yes, my lordship.
the order should be, it should be a speaking order. Nobody by their arguments can supplement something into this order. When the court is passing such an order whereby the order of imprisonment is passed, it should have.
Lordship,
all
kindly
the-
remand this matter to the.
that much
Trial.
water has, even according to their case, 2011 was the alleged violation of the.
Violation is violation any day.
My lords, may I pass on this judgment, my lords?
Because you came before a court which is where you're not supposed to come, and an order is passed, no,
That's-
it will lose its significance.
My lords, even according to their case, my lords, 2011 was the alleged violation, my lords. Lords, may kindly hear. Now, my lords, the decree was of the year 2010. Now we are in 2025, my lords. Remanding the matter, much water has flown under the bridge, my lords. Now, my lords, my humble submission.
Let there be an undertaking.
Please, my lord, that was my humble submission. I shall furnish an undertaking before this honorable court that I shall not interfere with the peaceful process. I shall obey the decree of the trial court.
Please find out what is the present position.
Yes,
My lord,
I'll-
lordship, may I
I'll-
kindly.
No, please find out what is the present position. Let him come up with an undertaking
Yes,
before the court,
yes, ma'am.
and let him clear if any interference or any thing is there, and file an affidavit, then we'll consider.
Yes, my lord. Let him file an affidavit,
what-
undertaking affidavit.
Before, you have to tell-
First I have to understand what is
We
the
have to understand
status.
what it is and
Yes.
file something by way of a memo.
Yes, my lord.
Let him respond on that and
Okay.
come up with an appropriate
Very well.
affidavit, then we'll consider.
Yes,
Then counsel for the petitioner submits that this order is passed
May I
in the
just,
year 2019, based on a judgment and decree of the year 2011. It
And-
is that
2010, my lord.
suit is itself is of 2007.
2007. Suit is-
execution petition
execution
itself
petition
is
of 2011.
2011.
In an execution petition of 2011. It is submitted that the petitioner is not interfering with and he is not disobeying the orders, the judgment and decree that is passed. And in that regard, he is ready to file an affidavit before this court. When counsel appearing for the respondent submits that, he'll get instruction in that regard and file the affidavit of the
Very well.
respondent. And after the affidavit is filed with the respondent.
Not by the, he has to file the affidavit.
It's happening that you have to tell.
Yes.
You have to tell what is
Status, present status of the property. Yes.
with regard to what is the present status, he'll come up with an affidavit. So that the respondent shall come up with a suitable affidavit, and basing on that, further orders will be passed. There's this matter on 4th of March. Yes. Interim order is there,
Please, my lord, interim order.
extended till then.
I'm not very particular about his imprisonment or anything, my lordship. I should be safeguarded my property. That's all, my lord. It is equal. It is equitable
Yes. that is
relief
it.
for
Next.
both of.
Jagdish Dixit for petitioner.
This case plot, courts may kindly accommodate 1 week for time for the responding. Appearing for petitioner. The file is not available there.
Why the files in the government office are now every time mixing like this?
Only 1 week.
Matter at the request of non-counsel for the respondent on 12th of March. Interim order is there?
Interim order is there, it may be extended.
But if it is extended on the last occasion, extended. Yes,
Next,
37.
10th of March, 10th of March.
Yes.
Serial number 37, VV Gunjal for petitioner. Vedmurthy for respondent.
Is application for amendment of written statement has been rejected. On the ground, my lord, it will take away the admission. That is the issue, my lords. The plaintiff had filed a suit for redemption of mortgage.
Where is the counsel for the respondent?
P. Vedamurthy.
Counsel for the petition is present, no representation for the respondent. List this matter as part here tomorrow.
Serial number,
Much.
serial number 38. K.R. Lingaraj
That's
for
for
petitioner.
petition, my lords, and yesterday only we have filed NOC Okalot, my lords. Kindly praise time, my lords.
You have stayed.
Yes, my lords. Kindly interim order may be extended, my lords.
And for the respondent block, and for respondent. And during the last occasion also, and then counsel for the
Have it on Friday.
Friday block.
List this matter on Friday. As it's submitted.
That's time.
It can't be. No,
Only
the game will not start from the day
Omelets.
you enter appearance. Sir.
Yes.
Your client is enjoying the interim order from 2019. Will not. If you are,
No,
if you want the stay is not extended, I'll grant it in the month of April or May, whenever you want.
At
You
least
want
10 days
stay
time.
and,
10 days time.
No.
Kindly, my lords.
This matter on Friday. What time you require for preparing the
Yes.
227?
Yesterday only we have got the file, my lords. Kindly.
Your client is smart enough to do all this. This matter on Friday. On Friday, if the matter is not argued, will not extend the interim order. Interim order is extended till then. Next study then.
Serial number 39.
Lordship, small accommodation, it might be on Monday because it's supposed to come from Davangere, Friday.
You have to come from Davangere.
Yes, Lordship.
Then Monday is not possible. List this matter on 5th of March.
Much of.
Interim
number
order is extended
39.
till then.
K. Ravishankar.
It is,
Chandranath
sorry
Advocate.
to reiterate the earlier.
Hmm.
That the order impugned is a order 39 injunction order. An appeal was filed. In the appeal, it was set aside. In the meanwhile, the suit before the trial court is dismissed for non-prosecution. And the application is filed, that is also been rejected. Then we filed an appeal before the miscellaneous appeal challenging the said order. The matter was heard and posted for orders, and the last occasion is submitted, it is posted on 31.
It is
Produced
good.
the,
So, yes, next
it
date
was
of
not,
the-
it is been posted on 22.
This matter on March 6th, it is submitted that the matter is posted before the trial court.
For final
judgment
orders.
For final orders on 20/2/2025.
Interim order subsisting maybe.
Order early granted.
I'm obliged.
Yes, 41.
Okay, then serial number 41.
Appeal for
Sampath
the
K. for petitioner.
Lord, the plaintiff's appeal, my lord, the suit for injunction, my lord, respondent is a Tahsildar. My lord, they want to amend the written statement. They filed an application, my lord, introducing the counterclaim, but my lord, they did not mention the prayer itself in the application. Lordship may kindly take the application, lord, at annexure C.
At what stage this is filed?
Lord, it was filed at the stage, my lord, the issues were set down for framing.
Issues were set on.
Set down for framing. It was not, issues are not framed, no, it is,
Trial has not commenced, number one.
trial was not commenced.
Then number two.
Lord,
What is the
the,
next step?
my lord, the annexure C, my lord, page number 25 is their application.
20?
25, my lord. Annexure C, IA number 4, my lord, the amendment they want to introduce it.
Defendant can take any number of inconsistent please.
Please, my lord, my only submission is that, my lord, they want to introduce the counterclaim, but they did not mention the counterclaim in the itself, my lord, the entire application.
They will, whatever, that is for your advantage.
Please, my lord, that's one, my lord, but that my only submission is that, my lord, the claim for the amendment is vague, my lord, that's only one humble submission, because,
If it is vague.
Please,
it
ma-
will
I-
be- They will suffer.
please,
You are
that's,
not going to suffer. Where is it in order?
my lord, the impugned order at, my lord, annexure. E, my lord, page 32,
32.
please, my lord.
Nine is the relevant.
No, they are denying your right and title to the property.
Please, my lord. Now, my lord, initially, my lord, they said, they are in para 13, my lord, they want to substitute it. They said, my lord, my title is, my lord, on the concocted documents, as my lord, they admitted, but the title is, my lord, defective. Now, my lord, they want to say, my lord, I mean, a totally imaginary possession. And the sale deed, my lord,
On two facts that
Please.
is filed even before the
Evidence.
amendment is, I mean,
Please.
before the trial has
Trial,
commenced.
ma'am.
Issues are not framed at.
Please.
And and the defendant is always at liberty to take whatever plea he wants
Please.
to take.
But my lord, in the para 30, my lord, they admitted, my lord, there is a sale deed. But my lord, they took a contention, it is a concocted and
It
fabricated.
will be decided that.
No, my lord, that they want to delete that.
Example,
Please, ma'am.
all these pleas are taken in the original written statement. What
Please.
will you say?
No, my lord, it's, my lord, that would have been continued. My lord, they admitted the sale deed. And they substituted saying that sale deed is a fabricated one. No, my lord, they want to delete the entire paragraph and say, my lord, the sale deed, that the possession, everything is illegal and it is their property. No, my lord, even I read the, my lord, the para 13, what they want to introduce. But the earlier comparison only is that, my lord, they admitted the sale deed executed in my favor. And my lord, there's also an observation, my lord,
Where is that admission?
my lord, that written statement, my lord, was not filed. My lord, I may permit it to hand it over.
Please take that. Which para? Where you
Para
admitted?
13, my lord, 1-3. I'm sorry, my lord, there's some underlining, my lord, it was carried. I'm sorry.
It is case of the defendant.
Please, my lord, that's a para, my lord, they want to delete and introduce.
Read that.
Please, it is a case of defendant that the plaintiff claimed the property under sale deed dated so and so. It appears that the sale deed was presented for registration on so and so, and that was came to be registered on so and so. The document placed for registration was kept under dark for a period up to 77/2013. The duration taken for the completion of registration is more than 1 year, 6 months. The pendence of the documented registration authority created doubts and inconsistency. The same was not been in any way narrated or clarified by the plaintiff in all the way. Hence, the defendant is not admitting the sale deed. Further, it appears that though sale deed was appears to be registered, but plaintiff was not succeeded in mutating the property in any manner. The plaintiff alleged created sale deed for Kaneshmari property, but the deed placed before this honorable court is a fixation. It has a lot of inbuilt creation. It is clear fabricated one. Accordingly, the sale deed cannot be document to claim any public property by plaintiff. It is also clear that the plaintiff claim is very silent with regard to the plaintiff.
So in
Defendant's
this para also they're saying that it's a government property.
Government property, my lord,
See
in
that some pictures document is created by you.
created.
That's their stand. Now let us look at para number 13.
Please, ma'am.
The new one as per the amendment.
Please, Annexure C, my lord, page 25.
Page number 33, I think.
33, my lord, that I said.
See that.
The defendant submits that the plaintiff's lords, I will not trouble, my lord, I will fairly admit. In this also, my lord, they kept on denying nothing. I will not trouble, my lord.
The agreed by the order passed on by number 4, dated 31st August 2019. The plaintiff is before this court. The plaintiff had filed a suit for injunction against the defendant. That's a defendant is a tehsildar. They have filed a written statement denying the right and title of the plaintiff, and they have stated that the document is a fictitious document and the property belongs to the government. Thereafter, they have come up with this application seeking amendment of the written statement. and they want to amend the provision of written statement as the defendant claims counterclaim, and also to delete entire para number 13. The plaintiff has filed its objections. The trial court, by order impugned, had allowed the said IA, where the court observes that there cannot be no straitjacket formula for allowing or disallowing the amendment of pleadings. The court observes that the defendant, by way of amendment, is incorporating additional facts about the claim of the defendant, about the title or the suit property in question, which would enable the court to decide the dispute in controversy. Therefore, the delay in filing the application would be compensated through costs, and accordingly allowed the application. Then counsel appearing for the applicant, appearing for the plaintiff submits, so the court ought not to have allowed the application. It is submitted that what is a counterclaim? The pleadings are very vague, and further, in the original written statement, they have admitted the sale deed, which is in favor of the plaintiff, and now by virtue of the amended pleadings, they're going to take away the said admission, and now they are denying the sale deed in favor of the plaintiff. By way of the amendment, the plaintiff cannot come up with such pleadings, and they cannot be permitted to cover up the latches and to take away an admission which is in favor of the plaintiff. And the court, without considering all this, allowed the amendment of pleadings. Next para, the government advocate submits that the court had rightly considered the application. By the time the trial has not commenced, and the defendant had not taken any inconsistent stance, but in fact, he has placed before the court some more facts in support of the earlier stand taken by him. It is submitted that if the amendment is not allowed, it would cause a lot of prejudice to the defendant, and it would, as rightly observed by the court would be in a better position to decide the controversy between the parties. Next para. Having heard the learned counsels on either side, peruse the material on record. The application is filed by the defendant seeking amendment of the written statement. This court has perused the original written statement and the amended pleadings, whereby they want to delete para number 13. And looking at both, it appears that as submitted with the learned counsel for the petitioner, they are not taking any contra stand. And in fact, it is a case of the defendant's right from the beginning that the property belongs to the government, and the sale deed of the plaintiff is a fictitious one. And by way of this para number 13, adding para number 13, they have elaborated on their pleadings, considering the fact that the trial has not commenced, and the trial court had rightly considered all the aspects and had rightly allowed the application, and its court finds no reasons to interfere. Dismissed.
Cell number 42.
Yes.
Jairam Bhatt for petitioner. HL Pradeep.
Interim order is there.
My lordship, kindly grant us 2 weeks' time to file objections, my lord.
Interim order is there. Extended. No representation for the petitioner. Counsel for the respondent seeks time. Let's this matter on 11th of March.
Grateful, my lord.
Don't extend the interim order.
43. Cell number 43, GJ Sulkapur for petitioner.
Hearing for the petitioner. Petitioner is the defendant number 1, madam. Petitioner filed the amendment of the written statement, madam.
When was the suit?
Madam,
Suit is
suit
of which
for
year?
declaration and injunction, madam.
Which year?
Suit is 2015, my lord.
2015. When did you file the written statement?
I filed the written statement on 24/9/2016, my lord.
When was this application for amendment?
I mean, issues framed on 9/2/2017, my lord. Thereafter, I
Issues
filed the
framed-
INM
Wait, 1 minute. Issues framed on?
9/2/2017.
Your
Thereafter-
application is?
I filed the application number IN number 12 for amendment of written statement 2/7/2019.
What is the reason?
The reason is that, my lord,
Where is that affidavit? IA?
IA, my lord, page number 24, my lord. Annexure D. Para number 2A and 2B to be inserted.
1 minute. 24.
Annexure D, my lord.
No, where is the affidavit stating that why you want this amendment?
26th, my lord.
The above case posted, read that at page 26.
Class of James PW2. In the meanwhile, I have filed my written statement. Yesterday, my counsel informed me that the dispute with regard to the execution of document, that is the sale deed, my lord. Sale deed dated 3/11/1990. I have not categorically mentioned in my written statement that I have got my plea in that my written statement.
So once the evidence is started,
Ah,
after the PW2's evidence, you felt that it is necessary at that time.
my lord,
Why
what-
was it not stated when you have filed the written statement?
My lord, kindly peruse the, it is entire suit is revolving on the sale deed dated 3/11/1990.
Correct.
According to plaintiff, my lord, in the plaint para number 12, my lord, kindly peruse
Please
it.
tell the court why these facts were not in your, were there any new facts or?
No, my lord, no new fact.
Then why did you not stay? all
I have
the
denied,
reasons?
my lord, I have denied in the written statement
That is
earlier, but
sufficient then.
my lord, what happened, my lord? That descriptions has to be stated, my lord. That is why there is no any nature of changing any nature of the suit, my lord. They have says in the para number 12 of the plaint, my lord, kindly.
You're not.
Page 31, my lord.
Come to the reasoning part.
34, my lord.
Read.
Page 34, my lord. The plaintiff has filed the instance suit against the defendant for declaration and for permanent injunction to declare that he is the absolute owner in possession and enjoyment of the suit scheduled property and restraining the defendants and their men, agents, servants, and the persons who are claiming the rights under them from interfering with peaceful possession and enjoyment of the suit scheduled property. On the ground that the defendants have no right, title, and interest over the scheduled property, and he has obtained the certified copy of the Pahani of the suit scheduled property and registered documents, came to know about the execution of the registered document in respect of the scheduled property. Though there is no base for making such entry as 16 guntas instead of 4 acre 7 guntas. In response of the suit summons, the defendant number 1, 4 to 6 and 7 were appeared through their respective counsel. The defendant number 7 has filed the written statement, but the defendant number 1, 4 to 6 did not file their written statement. Thereby, the written statement of the defendant number 1, 4, 6 taken as not filed and issues have been framed. And the plaintiff has examined himself as PW1 and also examined one witness PW2. When the case was set down for class of PW3, the learned counsel for the defendant number 1 has filed the instant application. The learned counsel for the defendant number 1 in his arguments has submitted that the defendant number 1 has not at all executed the sale deed which alleged by the plaintiff nor admitted before the sub-registrar office, but the defendant number 1 has not stated the said facts in total in the written statement. So in order to proper adjudication of the matter, it is just necessary to accord permission to amend the written statement, and injustice should be caused to the other side if the application is allowed and the price for allow the application. Per contra, the learned counsel for the plaintiff in his argument has submitted that the defendant has filed the instant application and the case was set down for class of PW3 only with an intention to drag the proceedings, and the proposed amendment changes the nature of the suit and cause of action. It will affect the right of the plaintiff, and moreover, the proposed amendment is not necessary to adjudicate the matter which is in dispute and praise for reject the application. So before considering the arguments canvassed by both the counsel, let me know the intention and object of the enacting the provision under Order 6 Rule 17 CPC that this court drawn its attention on Order 6 Rule 17 CPC, which reads like this: amendment of pleadings. the court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. So on close reading of the above provision, who files the application has to establish the following fact that the proposed amendment is necessary for
Yes,
the.
what do you say?
I will kindly see the written statement. This is suit for declaration filed by the plaintiff, my lord. D1, my lord, D1 has sold the property to D1 to D2 and D3. Then D2, defendant number 2 and 3 in turn sold to defendant number 4. From defendant number 4, I purchased, my lord. Defendant number 7 is the owner of the property, my lord. Keeping this in mind, kindly see the written statement of the defendant number 1 at page 21, my lord. The defendant number 1 had no
Who is
semblance.
this defendant?
Pardon?
This defendant is defendant number?
He is the
Defendant
defendant
number 1, my lord.
No, he doesn't have any interest in the property. Now kindly see the written statement already filed before the court at page 21.
Yes.
The defendant number 2 and 3 claims to have purchased the suit shell property from the defendant number 1. In turn, defendant number 4 claims to have purchased defendant number suit shell property from defendant number 2 and 3. Similarly, the defendant number 7 claims to have purchased suit shell property from the defendant number 4 to 7. The defendant number 1 had no semblance of right, title, and interest in the scheduled property. This is the written statement filed by this defendant number. Consequently, he could not have executed any sale deed in respect of the suit scheduled property. Now, this is his contention. Now, he doesn't have any interest. He has no semblance of right in the property. Then what difference does it make? Kindly say, I am the plaintiff will prove if he has executed sale deed or not, and whether this continuously sale deed is executed or not, executed by the other defendants or not. Now, once he takes a contention, he doesn't have any semblance of right. Now, now he wants to whether it's assisting, whether if he is a plaintiff, and if his rights are affected. Now, what is the purpose of amendment? To determine the real questions in controversy between the parties. Now, insofar as him, because the property is vested with the defendant number 7, the suit is filed by the plaintiff. Where is the question of determining the real question in controversy? This is why
Defendant number 7 not at all filed any objections to the IA number 12, my lord.
How are you concerned? You sold your property.
My lord, I have not at all concerned to the, I have admitted in para number.
Property.
No, my lord, I have not sold. That is my contention, my lord. I have not at all sold any property. I have been to the any register office. That is my contention in the plaint para 12. They have also saying that I have not at all sold the property to the defendant number 2 and 3, my lord.
Agreed with orders passed in I number 7. In OS number 72 of 2015, dated 6/11/2019. The defendant number 1 is before this court. The respondent has filed a suit for declaration of title and
Injunction.
declaration of title and injunction. It is a case of the defendant plaintiff that he has purchased the property from defendant number.
defendant number
Not, my lord, not, that is
Fine.
their ancestral property.
from defendant number 4 to 7. So,
He has purchased the
defendant number 4, from defendant number 4, I have purchased.
Yes, he has purchased a property from defendant number 4. And defendant number 4,
But he is representing D7, my lord, not plaintiff. Plaintiff not come before this court, my lord.
you are representing
Defendant number 7 only. Now, the dispute is between the plaintiff and the defendant 7.
Plaintiff
He
is
is
the-
taking
claiming
advantage, it's maybe collusive with the plaintiff.
No, please understand, I'm asking you what is the case of the plaintiff?
Plaintiff,
Plaintiff's case is he has purchased the property from.
no,
Plaintiff,
their ancestral
plaintiff says
property.
he has sold, kindly see, my lord. Plaintiff was the original owner of the property. He claims some portion of the property which he has sold. He doesn't mention any of these things in the plaint. But the actual fact is that plaintiff has sold the property to D1. From D1 to D2 and 3, they have sold. And I have purchased the property now. He has already sold the property.
I'm not on what is your case. I am on the case, what is the plaintiff's case?
Plaintiff's case is
Plaint, para 12, my lord.
Plaintiff had filed the suit to declare that he is the absolute owner of the property and also sought for permanent injunction, restraining the defendants from claiming under the defendants from causing obstruction to the plaintiff in cultivating the suit scheduled property in any manner and thereby interfere with the peaceful possession and enjoyment of the suit scheduled property and also sought for a permanent injunction. It is a case of the plaintiff that the property is the joint family property, the ancestral property of the plaintiff. He has not conveyed his right, title, and interest in favor of any other persons. He has not executed any registered document in respect to the suit scheduled property after he became the owner of the property. And he has not parted with possession of the suit scheduled property. The defendants are acting in a manner which is prejudicial to the right, title, and interest of the plaintiff. The defendant number 2 and 3 claims to have purchased the suit property from first defendant. In turn, the defendant number 4 claims to have purchased the property from defendant number 2 and 3. And defendant number 7 claims to have purchased the property from defendant number 4 to 7. Defendant number 4 to 6. It is stated that the first defendant had no semblance of right, title, and interest in the suit property, and consequently he could not have executed any sale deed, and in turn, the others have no right to sell the property. In the suit, additionally, the written statement is filed by defendant number 1. According to him, he has not executed any sale deed in favor of defendants 2 and 3. And now, by way of written amendment, he wants to file the written statement after the matter is set for the trial, after the cross-examination of PW2. It is a case of the defendant number 1 that he has not executed any document that he has already denied, and he wants to further expand the said fact by filing this written statement. Additional by filing this the amendment to the written statement that came to be dismissed by order impugned, wherein the court has observed that the plaintiff is seeking declaration and injunction. His case is that he has not sold the property to D1, and D1, it is a case of the D1 that he has not sold the properties to the others. The court observed that the fact whether D1 has executed the sale deed in favor of D2 when it is already denied, and by the amendment that he is seeking, or the facts that he wants to place by way of amendment, are not necessary to adjudicate the dispute involved in the case. Further, when an application after the amendment, when an application is filed under Order 6 Rule 17, it's for the defendant to say that in spite of due diligence, he could not bring all these facts to the notice of the court. All these aspects were not pleaded by the defendant, and accordingly dismissed the petition. Learned counsel appearing for the appellant, appearing for the petitioner, defendant number 1 submits that the amendment is very much necessary, and by way of amendment, he is not introducing any new case, and there is no prejudice caused to the other parties. He submits that the court, without considering all these aspects in a hyper-technical manner, had dismissed the application, and unless this application is allowed, it would cause a lot of prejudice to the plaintiff, to the defendant number 1. What about notice to the others? Huh? Notice to R2 and R3 is dismissed. This is item number 40?
40.
The notice to R4 is served. R4 to R4 notice to R4 is served. R1 is represented by the government pleader. The High Court government advocate appear for R1. R1 is who? R1 must be the plaintiff.
R1 is the plaintiff.
Huh?
R1 is the plaintiff.
Plaintiff.
Then
Served.
okay, what is HD?
SD served, madam.
BM Halaswamy
I am
for
appearing for
R7 and R5.
R7.
You are for R7.
R7.
What is HG? Oh, the notice is served on R1, R4, and on service of notice on R5, R6, and R5.
R5 refusal matter.
Huh?
Refusal matter, R5 and R6.
Held sufficient. R6 is held sufficient by order dated 23/1/25, and notice to R2 and R3 is dispensed with. Then counsel appearing for the defendant number 7 submits that defendant number 1 who has purchased the property and who has no interest in the property has come up with this application only to drag on the proceedings. He submits that the court has rightly dealt with the application and rightly dismissed the application filed by the defendant seeking amendment of the written statement, and no grounds are made out to interfere with the order passed by the court. Next paragraph. Having heard the counsel for the petitioner and the counsel appearing for defendant number 7, that is R7, peruse the material on record. The suit is for declaration and it's a case of the plaintiff that he is absolute owner of the property. He has not executed any document in favor of the defendants and they have no right or title to the property. It's a case of the D1 also that he has not executed any document in favor of D2 and D3. And it's a case of D7 that he has purchased the property from D4 to 6. D4 to 6 who has purchased from D2 to D3. The suit is filed by the plaintiff seeking declaration of his title to the property. The burden lies on the plaintiff to prove that he is the owner of the property and he has not executed any sale deed in favor of D1. D1 anyhow already denied that he has executed the sale deed in favor of the defendant number 2 and 3. The court had rightly dismissed the application. Number 1, the ground is that he has not pleaded why this amendment could not be sought before the commencement of the trial as mandated after the amendment to Order 6 Rule 17. Number 2, when he's pleading with regard to the denial of sale deed is already on record, and why this amendment is necessary for deciding the controversy between the parties. The court on both the counts has rightly observed that the amendment is not required under the facts and circumstances of the case and rightly dismissed the application. This court finds no reasons to interfere, accordingly dismissed. Remaining application.
CL number 22, my lord. CL number 22, my lord, I was 22.
What happened?
I was held up in Kotal 18, my lord, I couldn't appear. There's an interim order, my lord,
What happened?
Number
22.
What happened to that?
that is
We have filed a memo for dispensation of notice. Yes. Interim order may be extended and matter may be listed next week, my lord. This week we have small inconvenience.
Everything will not go on your convenience.
I understood, my lord. There's a function at senior's house, my lord.
This is matter as per the day in the month of March and interim extend the interim order.
5-3.
Obliged.
Respondent is there.
Respondents, they are all served.
No, unrepresented.
Only one advocate is there for them.
Was he present?
R4 and R.
Tell him that interim order is extended.
Obliged.
My lord, serial number 30, interim order may kindly be.
Serial number?
30, my lord. I forgot to mention.
Look at that.
Please.
ಮಾಡಿಲ್ಲಲ್ಲ ಟೋಟಲ್ ಮಾಡಿಲ್ಲ ಅಂತ that is on 5 date is on 5
ಅವಾಗ ಮರ್ತು ಬಿಟ್ರೆ ಆಗ ಮರ್ತು ಬಿಟ್ರೆ ಈಗ ಕೋರ್ಟ್ ಅಫ್ಸರ್ಗೆ this lady is
22 ನಲ್ಲಿ so all orders remains as it is date is on 5 I will explain
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಈಗ ಮೆನ್ಷನ್ ಮಾಡಿದೆ ಎಂಟ್ರಿ
For the password.
A humble submission, my lord. My lord, serial number 5 in the passed over matters. I've just received word that the senior is still engaged with arguments between different benches. So I seek an adjournment to the 7th of this month, my lord. 7th.
They have neither got back a confirmation or.
No, my lord. We have,
Kindly ask me to be
yes.
their plan.
I will share it across on email, my lord.
Then counsel.
For the next day.
Submits that. You're for the respondent, right?
I'm for the,
Respondent submits that the senior counsel is on Lex in the other court. Then counsel appearing to the petition submits that. They've already shared the joint parenting plan and they've not received any response.
no, my
from the
lord.
respondent.
The first copy, we had given the
The
response.
respondent shall respond to the same. This is matter adapt on when?
7th, my lord.
Friday.
Friday, yes, my lord.
Why not 6th,
My lord, he's traveling to Delhi, my lord. He'll be back on 6th evening.
7th? Yes, next.
Much obliged, my lord.
Passed over matter serial number 3. Vishwan serial number 3.
The child will come to the front of my from 10th of November until the 9th of January, usually went on the January, otherwise the interaction was extremely good. 9th was when last year was the half that day, the child was not interacting with the father, does not even look at him. 30 the officer avoided the mediation on Saturday and Sunday, 2 hours on 3 hours on Saturday and 2 hours on Sunday. So I filed a status report on the Saturday this morning.
When is that?
This morning, we're actually filed.
This is the Hemant Bharadwaj advocate.
Page 4.
Yes.
Until 10th of November, there was no interaction at all with the government. She would come and she was very soft. Page 4, 10th. At 5 days, visitation happened in the middle of advocate of third party for 3 hours of duration. Daughter is extremely comfortable. She and I were engaged in law-making activity. My daughter, in fact, showed a room toy in the third party visitation. Both of them class during play. 4th week, we had a drawing activity where she made pick up my mother and took a picture to me and told I was with her. Oh, that's the 10th of November, 17th of November on the next page. 17th November, again, the visitation was for 3 hours. My daughter and I made cupcakes. We made dictionary and all the third party visitation. I provided a set of flashcards with import identification of countries and capitals in order to help her with the game. I gave her a go. We also played a game. I said, throughout the period of visitation, my daughter was extremely happy and cheerful. But 24/11, they were very cheerful to play games with their father. 30th, visitation did not happen because of unwell. The 30th till 8th of December. So then it's page 7, 14th December. This was they decorated. She used to eat food along with the father. 15th Number 9, visitation happened in the respondent's mother, the child grandmother. My daughter did not interact with me to see whether it was the grandmother. I have produced videos, how she was the previous day. On 28th, how she was, 29th, how she was. But 30th again, visitation happened in the presence of an advocate as third party. Both of us spent, along with my mother, spent qualitative time. My daughter was very interactive, did some time experiments, and visitation went on well. 31st also wrote visitation 3 hours, 15 minutes. Though it was 3 hours, we take back 15 minutes more. First of January, visitation happened in the presence of the respondent's mother. Visitation did not go on well in the presence of middle grandmother. 2nd of January, 3 hours. Both of us, along with my mother, spent qualitative time. We played hide and seek and many other games. On this day, she went to her room where she used to stay while she was residing with me, looking for an old toy anywhere. Visitation went on well. This was the best visitation I've had till date. We enjoyed each other's company. 2nd of January. But 4th of January, there's a new third party who comes in to the picture. From that day onwards, visitation did not go on well. Observe that the respondent and my daughter spent time in my apartment complex before visitation. Respondent comes to the floor of my apartment. 5th, visitation happened to present unknown person, third party. Visitation did not go on well. Respondent had passed cover to the third party and the son from my side, the elevator of my apartment complex. So 11 months, hearing was of 9 months, thereafter 11 months. Visitation happened for 1 hour 20 minutes. Visitation did not go on well. 12 months, 1 hour 10 minutes. Visitation did not go on well. 18 months, 1 hour 18 minutes. 19 months, 1 hour. 25 months, 48 minutes. 26 months, 27 minutes. 1 to 28 minutes. And on 2 to 33. The daughter comes with a watch after the night hearing. 30 to 40 minutes, she does not speak to the father at all. Not to anybody, not even to the grandmother. After 40 minutes, she walks the door, opens the door and walks out. And the mother is waiting outside on the same. But I produced videos. Watch the kindly see the video. Video number 3. Yeah.
Yeah, we have seen, my lords, we have seen the videos. My lords may see the video. Just give us the date, please.
Video number 23 or 28-1. 28-12. Video number 23.
What is this date is?
28-12. But can you see? We are thinking, I'm writing something and she's writing something on my back and I have to guess what she's writing. Extremely playful.
Next to her sitting is the grandmother.
Grandmother.
Who is sitting in the chair?
Third party.
Their third party.
Yes.
Their third party is sitting in the chair. Our third party is far away. Our third party is not in.
What about the next day?
The next video. 24.
You can play.
Video number 24.
Okay.
Not if I forward straight away to. Because the grandmother was there.
This is 28-12.
Yes. She's very comfortable with that. In the grandmother case, that is video number 33. On 29-12 first, video number 26. 29-12 when the grandmother was present, this is the next day, video number 29. Sorry.
No,
Video
which
number
one?
26.
Have the dates.
Video number 26, get it 29-12. So very next day, the respondent's mother is present. She's not even looking at the father, just looking at the floor. Zero interaction. The entire duration she was this way.
Come to the latest one.
38, what's
These are all old videos.
December 30th. 3
No,
weeks.
no, after the previous,
30th, can we see 30th video?
before
next
the
day,
previous
after
order. Why are you?
Gone. 30th,
Video numbers.
video number 27. Both the third parties are present. What is the video number 30, on 31st of December? She's painting his face. And both the third parties are present. 31st of December. Number 30.
Yes, next.
The next video, Your Lordship, I can see, video number, on the 1st of January, video number 33. Again, the grandmother comes out, the maternal grandmother. He does not even look up at the father. 1st of January. Let's say we go to the next video, on the 2nd of January, the grandmother is not there.
Yes.
These are all prior to the last order, my lords.
Yes, next.
2nd January,
Video numbers.
video number. Thirty-seven.
34 to 39.
Yes, one particular video. $35. 35. She brings the teddy bear from her room. 35.
Yes. Now please come to
Now, latest video,
latest video.
after the 9th. Not the 11th of January,
Yes.
Video number 40.
Yeah.
In terms of the Lordship's direction, when the entire video is produced. From the minute she came to until the minute she left. And for the first time around, a new third party has come from the 11th of Jan. But from 4th of Jan. No interaction at all. He was that way through for 1.5 hours. From the 11th onward, every day, you can see any of the videos. 43, video number 43, 44, no change in the behavior, except the durations are getting reduced.
When is the latest one on 2-2?
The Lordship's order was on the 9th of January,
Video number 49.
49. Lordship goes to the end of the video. The Lordship will see that she opened the door herself. After 33 minutes, she opened the door and leaves the house.
Where is the father not to be seen?
He's there.
Drag that little bit. I think you need to forward it a little more.
About to create from maybe last 30 seconds, yes. About 20 seconds.
Every single visitation after the 9th of January, you open the door and leave. Your Lordship has spent more than 9 months on this matter. The mother has been counseled, your Lordship has recorded umpteen number of times how the mother is being instructed to allow the father to develop a bond with his own daughter. So from 2nd of January to 2nd of February, the daughter has to change. It could not have happened for any other reason except that some indoctrination in the child against the father. And an affidavit also has been filed by the mother now that the child was refusing to come out of the car to see the father. The Lordship has seen because prior to 2nd of January, the child is so happy about interacting with the father, with the grandmother, and everyone. The mother today files an affidavit saying the child doesn't want to go. I've been forcing her every time. And the Lordship are recording their own submission. But the child is having a good time and she's enjoying the visitation with the father on 27th of November. Both parties, both advocates submit that the visitation is going on very well. If there was a case of parent alienation, there would be no better example than the present case. Therefore, I think your Lordships have not used the word warn. I've advised the respondent that a long rope has been given to her. The court has been watching the conduct. So notwithstanding, I think she now, my humble submission needs to be shown that the court has, under parent secretary jurisdiction, the court can pass orders which may not be palatable. Otherwise, this would be the.
Yes.
May I just submit, madam? While we are on my friend's affidavit for the moment, may I just request my lords to see page 10. His submission is, and I will then go to mine. His submission is after the last date order and tutoring. Kindly see page 10 of his affidavit or statement, 4/1/25. 4/125, he says visitation happened in the presence of unknown lady. Details were not disclosed. In fact, my lords would recollect, we said how she's sending her friend and the friend's entire biodata, LinkedIn profile, phone number, all of that is being taken. And my lords, in fact, even commented that these kind of things from a third party should not be taken. It is the same friend who is going on all other dates when advocate is not able to make it. Kindly see 4/1, he says visitation did not go well. Then 5/1, again he says visitation did not go well. Then 9/1 is the order of the last date. So therefore, it is not as if the visitation has not gone well only from the last date order for any certain issues. Next page, page 12. Kindly see page 12, para 3. He states, there are behavioral changes in my daughter. She was reluctant to interact with me in the presence of the respondent, her mother, or with the lady who comes as a third party. Now, my lords have seen that entire video, P4 videos my friend showed. Whoever is a third party is sitting like a mute spectator on the side. In all the videos, I have gone through every single video during the lunch break. Whoever is the third party, whether it is her mother, after my lord's order, her mother is not going. It is the lady. They are sitting like a mute spectator in a corner of the room on a chair. Then, para 4, it appears that my daughter is informed of CCTV cameras. Now my daughter has been given a watch and she appears to leave the residence after a certain period. Not in a single video post this, anytime she's looking at a watch or anything, what's shown in the thing, in the end, on her own, she goes and opens the door and goes out. The third party is sitting, third party just mutely follows her, which my lord saw. Now, I want to just show, kindly see, my lords, my affidavit. What has been happening? Kindly see my affidavit, which I have submitted today. Para 3, she has been extremely reluctant to go, which we have been saying even earlier, all the physical touching and thing was going on, which after my lords made an observation, that has stopped. Thereafter, my lords, may kindly see para 3, page 2 of my affidavit. Para 3.
Yes.
I state that minor child has been completely reluctant to go. She has been so nervous that she sits under the seat in the car and hides and refuses to leave the car when they reach. And just for a moment, my lords may see page 7. Page 7, how she is sitting. And if I can just show one video, just for about 20 seconds. And I will just show to my friend also. 1 minute.
No, that's the whole reason why the court is saying she required some medical.
Yes, counseling. That also we have produced. We are following that. My lords may just see.
How many months it will go on?
My lords, may I just.
You know what is when she's all right one day, other day what is happening, and all the videos, what I have seen
Just
now.
my lords, I want to just make one submission. Ultimately, as a council, I think our duty of all of us is towards the child. It is not towards one parent or the other. Parents may have their own issues, but it is for the child.
Yes.
Ultimately, I see that as my obligation to submit before this honorable court. My lords may see just the photo on page 7. And if I can just.
Maybe is she behaving like how it suits the mother when during the presence
ultimately,
of the mother?
My lords, the parents, both parents may do anything. The videos, in fact, she is not coming out of the bottom of the car.
If she is not coming, why is she playing with the father like that?
No, I'm saying, my lords, she is in fact, my lords may see just for a moment that photo at page 7.
Yes.
Where she's sitting, not even on the seat. She is sitting under the seat. And when they reach.
This photo is dated where?
This photo, what is the date? This is a screenshot of what date? 23rd Jan. What date is it? One of the visitations after the.
That assumes more significance with all the videos they have.
We will tell the date.
It is on what day?
Yes.
She might have taken in her phone. The date must be there.
What date is it?
Second.
2nd Feb, last Sunday.
Where is that second
Now,
station? Let's
the visit.
That's the last visitation.
No. Now 2nd Feb, just for a moment, just give the same phone to. No, you just give the same phone, ma'am.
Just take that.
Just hardly 20 seconds, ma'am. My lords may just press the play. Just give it. My lords may just see when the mother goes to drop her at the bottom of the apartment, she's not coming out of the seat, under the seat of the car.
Who has taken this video?
Her mother, who's
What-
driving.
for
Mother is
what-
in the driving seat.
For what purpose?
No, because she is not willing to come out. Then the mother has told her to go. She has gone. All the allegations that mother is on the same floor is completely false. She drops her at the bottom in the parking lot. Mother waits in the parking lot. She does not even
This
come
is
up.
one.
Okay, now,
What
yes.
about?
Now, I will show my lords. Kindly allow me, my lords. Kindly see the same page, page 5. Page 2, para 5. Page 2, para 5. Visitation on 11/1. I'm sorry, bottom of the page. Visitation on 11/1 Saturday. Last line I'll read. The securities at the main gate recorded on my gate my phone number and name of all the three of us. At noon, it was informed to me that child opened the door and came out. Then number 6, visitation on 12/1. 12/1/25, kindly see the middle of the page. The visitation started at 2:13. It was 2 to 5 p.m. the visitation. Visitation started at 2:13. Mid-visitation, my child opened the door and came out by herself at 3:30. Then on 16/1, I received an email from the respondent blaming me of making the child aware of CCTV in his house. So she has come out in about 1.5 hours or 1 hour 10 minutes. Then visitation para 7, visitation on 18/1, Saturday, which was supposed to be 10 to 12. Kindly see next page. I'm not reading the whole thing. Next page at page 4, in the middle. My child was sent inside the apartment with the third party from my side. My child opened the door and came out by herself at 10:25. Hardly less than half an hour, she comes out. When I asked her what happened, why she's back early, she didn't want to be there, she said. Again, I received an email from the other side. Sorry, it was 1.5 hours, not half an hour, because that day it was from 9 o'clock. Then number 8, visitation on 19/1. Again, the last, third, fourth line. I was in my car. I suddenly saw my child get into the passenger seat at about 3:13, which started at about 2 o'clock. So in about 1 hour, 10 minutes, she has come out. Next page. Visitation on 25/1. Visitation started at 10:11. And as for the third party, my child opened the door and came out. I saw her come running towards me at 11:03. All these places, I just want to...
No, for all the 3 hours, mother will be there.
No, she's in the thing. She's in the
Yeah,
parking
she'll
lot.
be waiting in the
She's only in the car, in the parking lot. And all these...
time it is like this.
Yes. She doesn't go up. She waits in the parking lot. And in the my gate, she takes the daughter and the third party, goes inside. She's in the parking lot. They go up. Whichever floor.
So the question is, the daughter who is so comfortable a week before.
No, she was not. With
But then
great respect.
Do you deny that videos or
So what I want to say about those videos, my friend has very intentionally, the previous videos prior to the last order, in the last order, my lords in fact asked that the entire video should be submitted. So those videos are all 1.5 hours or 2 hours. Previous videos are hardly few minutes. In fact, the same videos, whatever the date my learned friend was reading out, 30th December, he said was wonderful. They made cupcakes or some video he showed. In fact, in my previous affidavit of 30th, I have in fact said in my affidavit that the father was forcing her to eat. And then the father said, please bring your own food because she was not eating in the house. And from that day, I started sending the food. That is my submission on 30th.
What is the solution?
So my submission is, my lords, my solution, I have a solution which my lords may consider. I have even been taking her to the counselor. Counselor has had many sessions. She's from Manipal. Kindly see.
I think the other day it was like other than that counselor.
Yes, we've gone to a different
What has
counselor.
happened to that?
We have gone to a different counselor.
What did she say?
No. I have her report is there. Kindly see, her report is at page 10 of my affidavit. And I have just typed it out. Kindly see page 13. This is her preliminary report. Page 13. Arohi came back after visiting her father. She reported father and grandmother were very nice to her and they tried engaging her with toys, photos, videos of their recent visit or vacation, but she did not feel good in their company and left before time. She reported feeling good with the thought that the visit was over. She reported feeling good overall, but having unrefreshing sleep. She was assessed on scared and CDI, must be some technical thing. She reported having fear of ghosts and monsters. She reported feeling protective about her mother. She expressed her love and gratitude towards her maternal grandmother. Thereafter, again, at page 15, she reported seeing and feeling monsters in father's house when she was younger. Vivid fantasies were reported, reports to be attached. So it is still going on, and the reports are, she's still doing her assessment. Now, my lords, my humble submission is, at the moment, my lords have given visitation of 2 days, Saturday and Sunday. Saturday 10 to 12 and Sunday 2 to 5. My lords, mother has been sending her. We are seeing that the child is uncomfortable. Earlier, there was great physical discomfort because there was physical overtures being made, which we brought it to my lord's attention, and those videos were there. Now, also, though physically, thankfully, the physical overtures have stopped, but she is on her own coming out. Nobody is there. Even those videos can be seen. Nobody is tutoring her to stay and to not stay. She is walking out of the door. She's a child of about 7.
That she was not doing earlier.
My lords, she was doing even earlier. All the visitations were not of the full duration. Not all of them.
So now it should go on
now,
like whenever
now
she wants
my
to come,
submission.
she'll
No,
come,
my
and whenever
submission.
she wants to go, she'll go.
Ultimately, my lords, can a child be forced? My submission is.
This theory of forcing the child and telling it that things will be done. Now, she is with the mother. She would say that she'll not go to school, she'll not do anything. Will the mother let her?
No, mother is sending her. May I
This
make a
child
submission?
psychology, no.
Yes.
Please. This theory of child psychology, only in case of this parents where they're at loggerheads, won't apply. It applies everywhere.
Of course.
And particularly, mother cannot take advantage of the fact that
No
you know
one
the
should
child
take
doesn't
advantage.
want to do it.
No one should take advantage.
Doesn't want to do so many things.
No one should take advantage. Not mother or
There should
father.
be a solution for that.
I
And
would.
the- and have medical issues, there should be a participation of the father. The counsel should interact with the father also. Shall find out what is happening. When the girl who sometimes behaves, like sometimes father is good, grandmother is good, sometimes she doesn't like, and she shows her over this thing to the maternal grandmother, and she wants to please her.
No.
We don't know what are all
We
the
don't know.
compulsions.
We don't know. May I make a suggestion for my lord's consideration? May I make a suggestion? At the moment, my lords have given Saturday, Sunday.
And there is no meaning in giving the visitation for her to come and go.
Exactly. That's why I'm suggesting. My lords have given visitation Saturday 10 to 12 and Sunday 2 to 5. Instead of just coming and going and this whole paraphernalia that all the parents are doing, let the child be comfortable. The child should, of course, go for visitation, what my lords are asking. With the similar thing, let it just be one day of the week. Let it be either Saturday or Sunday.
So how does it going to change?
At least the child will not be
What is
stressed that she
happening
has
in
to
the-
go
what
for
is
2
happening
days
in
when she's
case-
not coming out of the car, my lords. My lords, I ask, I'm a parent. I only say, yes, be bonding. In fact, in so many cases, we have said that even when the child is not agreeing for developing the bonding with the other parent, it has to go, the child has to go, and slowly the child will develop the bonding. Yes, we have said that. But my lords, I just ask when we see these things where the child is hiding under the seat of the car, like a small little animal not wanting to come out. And she opens the door and comes out of her own, which my lords have seen. No one has tutored.
What is the help she's getting? What is the medical help she's
She
getting?
is undergoing, in fact, the counselor,
And
what I've
what
been
did the
told.
counselor say? What is her report?
In fact, the counselor is going to give the report in a week, is what I've been told. This is, she has already preparing, she has
And
had
where is
several
the-
sessions.
what is
In a
the
week,
father-
the counselor will produce.
The father's interaction with the doctor, and it won't be done independently. Father's that.
Father can be as of now, one minute. No.
Did the counselor see what is the daughter's reaction when she's interacting with the father? Did she analyze it?
At the
Is
moment.
it not necessary for
No,
the
at
counselor?
of course, we don't know technically. At the moment, the counselor has not interacted even with the mother. The counselor has interacted only with the child. Even the mother is not in the sessions with the counselor. She's having weekly
And
sessions.
this, she's been doing it for months together.
No, not this counselor is after last order.
Then
Because
we'll
this
pass
is,
an order, we'll pass an order.
because this is a
Let
new
there-
counselor.
Let there be an interaction with the whatever that visitation is happening. That visitation, one day on a Saturday, that session shall be with the father. And let the counselor analyze what is happening between the father and the child.
May I suggest one thing? If my lords feel that the counselor should meet with the father, of course, we have no difficulty. Counselor can meet with the father can meet with the same counselor.
No, no,
But meeting
father-
with the child and the father, my lords, here we are already in a situation where the daughter is uncomfortable. We are extending that discomfort for her. With great respect, we are extending the discomfort for her. The counselor can definitely interact with the father. She has in fact not even interacted with the mother. She has interacted presently only with the child.
It will not go on like
So-
what the mother wants it.
No, it is
There
not
a
about the mother
procedure.
or father.
When the Nimhan's doctor said there is a procedure to interact with the child, there is a procedure for the treatment. And it is not forever, just like that the girl will come, they will talk to the girl and send the girl. Girl will say in her dreams, she is seeing the monsters. So she stops seeing the monster in the
No,
dreams.
there
They
is
will
not. In fact, the
They should
counselor
know how
works
to-
with the child.
If the therapy or the counseling is going on in a proper way, the doctor should find out what is the body language, what is the mindset
course,
of the girl
of
when
course.
she is meeting the father.
My lords, I want to just ask myself a question. These are professional counselors from where? Manipal Hospital. Manipal Hospital.
No, that's her choice, that she wants to go to Manipal only.
No, Manipal, she is.
Nimhan's, world recognizes
No,
Nimhan's.
Nimhans, there is no difficulty anywhere. There are
According to her,
There
they're
is-
medically, they are not.
My lords, no, not at all. Not at all. That's not the issue. The only reason Nimhans was not continued after some time is because Nimhans wanted the child to be residentially placed there,
Because they know how to deal with
which
the patient.
was quite a severe thing for the mother to
They know,
handle,
they know,
that she
they know,
is
they want to know,
residentially placed.
they know how to deal with we are not here, neither you nor I tell the Nimhan's people how do they
My
deal
lords,
with
there
that,
is all these institutions are well-known institutions. It's not as if Manipal, she has any particular,
What I'm
this,
surprised is Nimhan's is looked at on a different footing.
no.
compared to,
It is not
in
about
terms of
Nimhans or
mental health.
Manipal. It is just,
People throughout the country comes to Nimhan's and a person who is in Bangalore says, no, I'll not go to Nimhan's, I'll go to Manipal, I'll go to some other counselor, but not Nimhan's.
my lords, there is different views of how treatment can be done. Different counselors, different psychiatrists may have different views. In Nimhans, for example, if they said she has to be an inpatient and be residentially placed there for their observation, that was the concern.
No,
Now-
because that time you're not
Yes,
appearing,
I
you know
was
what
not.
has transpired.
Yes.
When
I have
when
read
she
the,
said that she has to be admitted, I felt that she's a small girl and admitting
Yes.
her in the hospital.
yes,
I spoke with the director Nimhans.
yes.
So what he told me is, particularly the girl, the kind of, relation both the mother and the father are having. And the whole day, the girl would be with the mother. And whatever kind of, the girl will be having with the mother, grandmother, and what are their feelings, how she is carried with that, we don't know. He said, it is very difficult to treat the girl in her mindset and with the background of her parents, the strained relations. It is not possible. I said, don't let the girl be not admitted. and let
Admitted.
there
That
be
was the concern.
let there be like the counseling. He said it is not possible. And that we are seeing from the last 9 months, absolutely no change. And
My
forever
lords, I
the father
asked-
will be looking at it.
No,
the
that
same
was the
thing
concern.
happened.
What my lords
If
raised.
the same thing happens and the mother is on at the other end, then at the same time they'll be saying that, oh no, it is also child psychology.
My lords, I
That
would
is all-
say that both parents would not be comfortable that such a small child is admitted in a hospital like this. Both parents, I think, should not be comfortable about that. I don't think a
Parents should be more concerned about
the child.
the girl's health.
Of course,
And you can't, for some reason or the other, It can't be, the intensity of the treatment that is required, whether she's undergoing or not, doesn't appear to be. because there is
May
no
I
change.
suggest one suggestion?
Yes.
This counselor who has been meeting the child and trying to
What's
interact
her
with the
name?
child,
Where
Dr.
is she?
Neetu. Dr. Neetu, she has in fact said that within a week she will give her complete reports.
So we'll do one thing.
Can we
Let-
wait
let-
for a
let
week?
there not be, let us leave about that counselor. I will direct NIMHANS to interact with the girl, at least, no, not as an inpatient.
Not as an
At
inpatient.
least, like 5-6 sessions, 3 sessions along with the mother, 3 sessions along with the father. Let them assess what is happening when the girl is around the father and how she is along with the mother, and let them place a report before the court, how the things are happening. And this will not go like this.
May I suggest one thing? The NIMHANS, my lords, may direct. There is nothing, and I'm grateful that my lords say not as an inpatient, because I think that is at least keeping the child's overall routine and all that and her age in mind. But can the interaction of the child, let there be the parents, let the counselors assess the mother and the father, but not with them. My lords, that will in fact.
What is the difficulty? That I should know, that the court should know. If you have any kind of, what is the problem? Why should the father should not be there? No, he is, no, the
No,
doctors are
I will
present.
share that. I'm not even her.
No, doctor is there. What is the problem? That I want to know.
May I suggest one more?
Yes.
Let the fact whether the only reason I'm saying this is that the basic principles of child psychology, I'm not an expert, but handling a lot of cases where children are under abuse, the basic principle.
That now you cannot say that.
No,
Under
I'm
abuse
saying.
is over.
No,
Now, in fact,
I'm
if that
saying
under
where the
abuse
child.
thing,
See, my lords, the
court
child.
court has quashed that complaint. She has
I'm not
taken
talking
any
about that
steps.
complaint and the legalities. My lords, the court may have quashed it. We are not.
No. Legally speaking, we have to take it. There is no such abuse.
My lords, the child is behaving in a certain way. With the child, what is the reason for that child's behavior? We cannot say. Child is behaving in a certain way. The child has a certain experience for whatever reason, rightly, wrongly, legally correct or not. Child is behaving in a certain way. Today, if you put the child with the same person for wherever she's uncomfortable more and more, let the counselor decide. Let the psychiatrist.
She is with the father. She is with the father for 2 days. For 3 to 3 hours.
3 hours.
2 hours.
2 to 3 hours.
5 hours.
Yes.
And you say for the counseling of 1 hour, father being present with the doctor would affect her health.
No, I
am not
meant
able to understand that.
And beyond that. Then let it be through for within that time 1 hour if they are requested
That's
to
what the
go,
court
let
is
them
also
go during
suggesting.
that time.
That's what is the court suggesting.
Yes.
At
during
that point of
they
time.
can go.
And the counselor who is doing the counseling from the last 6 months, what is her report?
We'll get it.
Manipal doctor's report.
We'll submit it.
I'm just
I'll
saying
submit
that.
it. No, I'll submit it. This counselor's report will come in a week. Previous one also we'll submit. This one also we'll submit. If my lords want to even refer to NIMHANS also, we will submit. There is no denial for.
We want to know what is the psychological condition of the girl. It can't go on like this.
How long? So I'm sorry.
Just go through this. No, on 4th of November, my lord was pleased to pass an order. Since the mother was reluctant to send the child from NIMHANS, my lord directed me to find out, the father to find out any other hospital that will take the child for counseling.
No, but it should.
Can you see this for the
It should not be inpatient.
Head of department, psychiatrist, HOD consultant psychiatrist, Manipal hospitals. Mr. So-and-so, father of so-and-so came to discuss about the possibility of assessing the child and intervention in our hospital on the request of the court. Our department will not be able to do the needful for her in view of lack of child psychiatrists and child psychologists in our department and lack of inpatient facility. I would recommend treatment at the child psychiatry department at NIMHANS, even though the facilities and expertise available there. So Manipal hospital says this. One more hospital,
No, we don't want inpatient. My lords, we have no difficulty with NIMHANS. As long as it is not inpatient. My lord suggested that the only reason was for not inpatient.
What I want to know is, like, If something is good for the girl, who is the mother to say that she shouldn't be impatient? Something, if an operation has to be done, for example, let's say somebody do not like to be an inpatient. An operation has to be done. He has to be an inpatient. No, I'll say I'll go and consult
No,
and
the
come back.
child, my lords, the child was to be, if I can reconfirm, child was to be kept in the hospital without the mother.
No, with the mother. With the mother.
Yes, but to,
But you know, it is, she shouldn't be looking at the
my
other
lords,
side of it.
my lords have in fact very kindly said that my lords also spoke to the director.
He
And in
said
fact,
this is a case where 100%, there, unless and until that girl is admitted, it cannot be. That's the reason why the court, because court also understands looking at the, you know, the, always at the problem of the girl. But from things how they are
in
happening.
fact, I believe even after she was taken there, she fell sick and all of that.
She
My
felt
lords,
sick
may,
because there are reasons for that.
Yes.
Every day the girl is going to the school,
No, no,
25 kilometers traveling up and down.
after she
And
apparently,
she was
I
not
think-
having proper.
My lords, let
water.
there be a, what my lords in fact kindly suggested, that not as an inpatient, but for few sessions, and let it be during the same time, let the report come.
If she has been cooperative by this, after the 6-7 months, something could have been done to the child. We have to look at the, you know, that large, that big aspect of life.
Ultimately, they have to give a report. We are not here to dictate what report they can give. The experts have to give a report.
No,
What
by
is
this
the,
time, no, I can understand if the counseling is going in a right way, they're able to assess it, like what is the problem? What are the remedial steps to be taken? Nothing. Every time you take, she will say like, I have seen monsters, that is what she'll record. Children might see monster for so many reasons.
my lords, kindly give me. May I request a week's time, because by Saturday is what I'm told, this present counselor's report will be available. If we can wait for a week, we'll place those reports with my lords.
Let it be, let there be.
We'll place those reports.
Let that report be there on record. Apart from that, now every Saturday, where the father meets the child, that will be in NIMHANS. I'll ask them to give an appointment on Saturday.
Can we do that? What? I'm sorry, we are not dictating. We are, my lords, we are struggling to see what is the best for the child, which my lords will also appreciate. Here, as a parent, the parent's interest and the court's interest is to see what is best for the child, not to dictate what one parent or the other says. And the attitude or the submissions of the council to say parent is dictating. My lords, we are together trying to see what is best for the child. And I believe that is the endeavor.
What is best to the child?
We are
Which is
trying to
acceptable
see.
to the mother.
No, not at all. What
The
is
wants
best?
it this way. So whatever
we
is,
are only,
that
we
would
are
be
in my
best for the child.
hands. Ultimately, we are in the hands
But
of
what
my
is
lords.
that? Because the court couldn't make her do anything till now.
My lords,
Only
still,
the
it
lenient
was
attitude
only
of
where
court
the
has
issue of
leading to this.
inpatient came, where she had to be admitted. Now, my lords have kindly suggested, let it be, as my lord said, that during the, not as an inpatient, but for few sessions, so that a report may be submitted. My lords, we are in my lords. That can be done. We will submit this report also.
Yes.
So that we are there before my lord.
We'll have this matter on 6th of March. And till 6th of March, all Saturdays, there will be a session in NIMHANS with the, the father will be present and they will let them assess.
My lords, in fact, suggested that some with the child, some with the mother, some with the father. I am reiterating.
No, correct. Then what is, no,
I leave it.
The mother is very happy with the child. She has no problem.
No,
But
for
the problem is
for
with the
the
father.
visiting,
Saturday, because that Saturday, no, some other, if she wants, if the session shall be with the mother, that could be a some other day. Saturday, the
just
session
for
will be
me to understand, my lords are suggesting that the Saturday visitation
sessions
is
will
in
be
the
with him.
presence.
Will be with him. Will be with him in the sense.
In the presence of the NIMHANS.
In the NIMHANS hospital.
Very well.
The doctors will be assessing her while she was with the father. And what is happening? They will try to understand it and place a report before the court.
let, no, if the court order, let that court order be there, we are in the hands of my lords. Because as long as the court order says that, definitely NIMHANS also will have to assess in that manner.
Earlier,
Because her only anxiety was, which I assured her that as long as my lord's order is there should be no difficulty. Her anxiety was that earlier, the again inpatient requirement was requested. So as long as that
Earlier-
is not there, there should be.
earlier this court has passed an order to assess the girl. And also, that order is stated,
The report, my lord, was submitted.
no, order.
Directly assessment, my lord.
Hmm.
Lord, it's not done. Lord, 12/6.
12/6/2020.
Four.
On 12/6/2024, court had directed both the parties
Paragraph 4.
to appear before NIMHANS for counseling. And the court has observed that the girl shall be taken to the NIMHANS Bangalore for counseling. The doctors at NIMHANS shall give the therapy sessions required. They shall interact with the girl separately and shall find out about her apprehensions and about the statements that father is touching her inappropriately.
Next sentence.
This court has also observed that the doctor has to take a special note of the fact that when she met the father on Sunday, when nothing has happened, why was the girl saying about the father touching her in an inappropriate manner? What made her to tell such things about the father? And she also talks about the nightmares. And this court had observed that on a weekly basis till 6 July 2024, they shall take up counseling therapy sessions. What has transpired on those sessions? A detailed report shall be sent to the Registrar Judicial by Monday, that is on 8 July 2024. A report is placed before the court stating that under the circumstances, unless and until the girl is admitted as an inpatient, it will be very difficult for them to assess. Thereafter, the mother has joined the daughter in the hospital as an inpatient and submitting about some difficulties being an inpatient and some ill health.
Child was falling sick.
And she falls sick and she was admitted in some hospital. And for the reasons, it is stated that the child was not comfortable. From there on, it is submitted that she has been taking counseling in Manipal Hospital. This court has passed has granted registration to the father on several occasions. Today, it's a memo or an affidavit? An affidavit is filed before the court that some days the registration went on well. And from the date the order is passed.
4th of January visitation is not going.
Till 4th it went on well, and thereafter the girl was reluctant to look at the father. And even before she herself was going out from the house of the father within 40-45 minutes. It is submitted that for the reasons which are not known to the father, and maybe at the behest and being carried away with the mother's emotions, the girl is not interacting with the father unless and until orders are passed. It would be very difficult for the father to interact and develop a bonding with the daughter. Then the senior counsel appearing for the respondent mother submits that the mother is making her best efforts to see that the girl develops bonding with the father. But so many times she's showing her reluctance to even get out of the car. She's hiding under the seat and she was reluctant to go and meet the father. It is stated that now the girl is taking the counseling with another doctor by name Dr. Neeta.
No. Dr. Neetu Tiwari in Manipal Hospital.
Dr. Neetu Tiwari at Manipal Hospital. And they will place the report before this court. It is submitted that admitting the daughter as an inpatient is not is not in her interest. Then counsel appearing for the father submits that, in fact, when they sought for asked the doctors for a clinical analysis, they have stated that the municipal hospital is not equipped to do that, and they can better take the child to NIMHANS. It is submitted that the girl is not getting the best medical help available. Next part. Having heard the Learned Senior Counsel for the Central and Counsel for the father and the Learned Senior Counsel appearing for the mother, this court has perused the earlier orders that are passed by this court. The order of joining the girl in NIMHANS was on 12/6. 12/6.
Your lordship's reference to the man's was on 12th of June.
No, order was passed on 12/6/2024. And thereafter,
On 10/7, your lordships have done, actually the remand report, it said that child required.
on 10/7/2024, there was a direction to join the girl in NIMHANS. Right from July 2024 till now, there appears to be no much difference in the girl's in the girl's attitude towards the father.
Sorry, lordship, kindly note that on certain days she's extremely happy and certain days.
As on certain days, videos are placed before the court. In some of the videos, it appears that she was getting on well with the father. In some of the videos, she was not even interacting. What is the
Apologies,
reason?
my lords may also then note, as observed on the last date, in many of the videos, the father was being extremely physically
the-
aggressive with the girl.
What is the reason?
Yes,
for-
she is physically,
What is the reason what is the reason for the girl to behave in that way? There are no reports placed before this court. Earlier on the last occasion, it was brought to the notice of the court that father is always making her, touching her, and she's not comfortable, and this court made it clear that when the girl is not comfortable, father should not indulge in any of those activities. The fact remains is, the child, whatsoever is the reason, her behavior is not normal. And both the mother and father accept that she has some psychological issues which has to be addressed. According to the doctors at NIMHANS, unless and until she is admitted as an inpatient, it cannot be done. Mother wants her to have the regular therapy sessions. What is the input from the doctors? What is their assessment is not known. And when this is a serious problem, it cannot be dealt with in such a casual manner. This court is conscious of the fact that earlier the NIMHANS doctors have said that unless and until she is admitted as an inpatient, they cannot assess her. That, however, considering the facts and circumstances and the facilities that are available at NIMHANS, right at this point of time, this court is not inclined to it's not inclined to pass an order directing the daughter to be admitted in NIMHANS. However,
as an inpatient, my
That's
lords
what
may
it's-
just clarify.
inpatient, but at the same time, the manner in which the counseling is given to the daughter, to the girl, doesn't appear to be as per the requirement. In
My
the
lords
view of
may
the
not
matter,
be, sorry, apologies, my lords, to, for this honorable court to say that the counseling is not appropriate or what.
Because no
We have not
report is
yet placed the reports.
You should have been.
We are yet to
Because
get
till
it.
now, no report is
May-
placed before the court.
And those reports will be placed.
Before the court, and whatever that are placed before the court, they do not analyze the situation, improvement, if any, and what are all the means by which they are dealing with the problem, and how much time it takes, or nothing has been placed
No,
before.
we
the
are yet
court.
to place it.
It is submitted that they would be placing it in a while, and they require some time to place it. Considering the facilities they're considering the doctor, they're considering that the NIMHANS is known for its analysis, for the mental health, the facilities at NIMHANS. This code deems it appropriate, pass the following order. On every Saturday from now till 5th of March, from today, today is,
4/2.
that is from Saturday, from 11th January till 11th, 11th February to 8th February to 5th of March, on all Saturdays, the girl shall be taken to NIMHANS for counseling. And during the counseling, the father, as per the requirement of the doctors, if they want to analyze with the presence of the father, without the presence of the father, or they require the mother's presence also, accordingly, the counseling shall go on.
From 10 to 12, same timing, if that, my lords can state that.
From 8th to 5th.
No, the timing, 10 to
The timing
12.
is between 10 to 12.
No, but it can't be, it can't go on for the whole day. No. No, it can't, no.
Some free hand has to be given to the doctor, we cannot. tell the
No,
doctor,
I'm
"You have to
sorry,
go to
if the reason, my lords, in fact, also very rightly pointed out that at this stage, not having inpatient, and even this counseling from 10 to 12. I can't understand what is the difficulty.
The doctor wants
It
to
can,
go
if
one
it
hour
goes
more,
on for,
1 hour less.
no, if it goes on, it can even go on for whole day. Are we going to now subject the child for like a 10-hour or 5?
I don't understand. For everything, mother has a problem.
No, I'm
And
only
every-
saying my
because
lords
mother
may
has, No, mother has the capacity to have a senior
No,
counselor.
even the
So-
father has.
No, it's
Father
not
also
that
has his
father-
whole battery of
but the
lawyers.
But everything she can't dictate.
No, we are not.
Everything like this has
No,
to go on
we are
like
only
this,
requesting
10
my
to
lords to
12.
put the
Then
time.
How
We
can
are-
a court tell 10 to 12? I'm saying, but it is for the doctors to say that when is it convenient? Let the doctors at NIMHANS fix a convenient time on Saturdays, and accordingly, as per the time frame fixed, the counseling shall go on, and basing on the assessment what they could arrive, a report shall be placed before this court by 7th of by 3rd of March, by 4th of March. Lissus matter on 5th of March. The Registrar Judicial is directed to communicate this order to NIMHANS.
May I?
And on Sunday, next para, on Sunday, as per what was the real time? 2 to 5, as per the earlier arrangement made, the father can exercise the restriction.
My lords, just on the date, apologies. 6th or 5th or 6th, I have some personal difficulty. Could it be 11th March?
11th
March.
11th is then
Tuesday.
the report shall be placed. Then they have to undergo between 8th of February to
8th of,
8th of February to 8th of March.
or if the report can be given by 5th or 6th.
8th of February to 8th of March. and report shall be placed before this court on 10th of March.
And
On
also
11th of March, 12th you can appear.
12th is fine.
List
But
is matter
can
on 12th.
would my lords be
No,
kind enough that
sessions
we
will be
also
good for her. Sessions will be good for her.
No, I have no difficulty with the sessions. Since my lords have asked for the report to be one day before, could we also get a copy of the report, both councils?
No, that I think the court can only give, because it will come in a sealed copy. We'll
Yes,
give you. We'll
so
give you
that
when
we
it
can
comes.
also have
Have it,
access to
and then
the.
on that day, we'll give the, I'll ask the registrar judicial, I'll go through the report, I'll ask the registrar judicial to give a copy of it.
Yes.
And even if you don't appear on that day, we can give you some other day also.
No, even if we are there, if we get a few hours to go through it, it can be taken up.
Or we can have a passover on that day.
Exactly, that's all.
Huh? Yes.
Sale number 44. Sale number 44. Telecast Gowda for petitioner. 44.
What passover now, tomorrow? Tomorrow.
Tomorrow, what 5 10
Tomorrow is
minutes.
45.
Sale number 45 tomorrow. Sale number 45.
At the request of learned counsel, the petition tomorrow, yes. 45,
Sale number 45.
yes.
Speaker M. Deshpande.
What happened last time?
Last time, your lordship, about to dismiss the matter, my lord, because petitioner relied upon on judgment, my lord. That was against them itself, my lord. Suit for ejectment, my lord.
Directly not fine to. Matter by the local entity. Inform the same what the court expressed.
No, why should you inform to the client? You are the one who is arguing the matter. What is that you should, if the court is dismissing, you should inform him and take permission. We'll have it tomorrow. List this matter tomorrow as part her.
Sale number 46.
Okay.
46. Srinivas T for petitioner. MD Chandrachula for respondent.
Where is the counsel for the respondent? Counsel for the petition is present, no representation for the respondent. This is as part her day after tomorrow.
Sale number 47 adjourned. List number 2. Sale number 1. Mitten SK for petitioner.
Yes.
The amendment application was filed by the respondent. The respondent has filed a suit for injunction, my lord. The client found it impatient for 17, my lord. The suit for bare intention.
You are the defendant.
I'm the defendant for the client.
Where is the order?
10 minutes. The amendment application of court that has been allowed, agreed by that.
Come to the reasoning part and read. Come to the reasoning part and read.
The reasoning starts at page number 14, paragraph number 9. Para 6, the reasoning is found at paragraph number 9. On reading of the plaintiff is transferred to the necessary trading with regard to relinquishment, it is called. Though the plaintiffs are sought for additional credit, the same does not change the nature of the suit as there is a foundation in the unlimited trade with respect of the relief not to be added. The proposed amendment is necessary for the purpose of determining the real statement between the parties. The proposed amendment alone declares the not be reduced as there will be having an opportunity for additional statement. The contention of the remaining of the relief claim by the virtue of amendment is barred by limitation cannot be considered because the limitation is a question of law. In fact, the trial has not yet commenced. That decision made by the defendant is not helpful to her. That the fact and the court is of the considered opinion the application for the plaintiff decision to be approved. What has happened is
Suit is of the year 2011. When was the amendment to application is filed?
17, my lord.
Yes. Let's see the affidavit.
Page 44, annex cherry, my lord.
Line is found at page number 17.
Affidavit we'll see.
After.
Page number 47.
Yes, my lord.
Para two. The subject the present one came to find seeking the pair of temporary injection, extending the difference from netting or cleaning the scheduled property, including formation of whiting of the road, etc. There was a limited ad interim order protection for a couple of days, which ultimately came to be vacated. The year 2014, she was successfully initiated arbitration proceedings in AC number 61 of 2014, performance of joint development dated 17/1/2007, and for other names. In the said proceedings, before the arbitration center, we find our statement of objection for the account claim. Said arbitration, an issue was raised, issue number 3 as to whether 9 defendant hearing the claimant in the arbitration was not entitled to relinquish the property under the joint development agreement dated 17/1/2007. The amendment joint development agreement dated 3/12/2008, the power of attorney dated 17/1/2007, the special power of attorney dated 3/12/2008. The said issue has been answered in our favor by holding that the 9 defendant hearing has committed a breach of joint development agreement. The 9 defendant could not have released the relinquishment of the land in favor of both Bengaluru Mahanagar Palike without there being any right conferred on the claimant. Similarly, on issue number 10, the learned arbitration of claimant has held that 9 defendant hearing has no power to appeal the rights of further. I state that it is therefore clear that the defendant, and more particularly the first to 8 defendants, could not have got relinquishment deed executed in respect of the scheduled property. Consequently, the relinquishment date dated 12/1/2010 executed by 9 defendants is invalid in eyes of law. Therefore, the land will have to be restored back to us. I submit in light of the above aspect, it becomes clear that relinquishment deed dated 12/1 executed in favor of the Bengaluru Mahanagar Palika has no value in the eyes of law.
How can it be all these additional prayers by?
Lord, I'll just explain, my lord. Lord, there was a joint development agreement, my lord. I am the owner of the property. There was a joint development agreement in favor of my learned friend's client, my lord. There, my lord, there was no power given under the joint development agreement to relinquish any portion of the property to the BBMP, my lord. What happens, my lord, is voluntarily they, my lord, relinquish and, my lord, collect TDR in their name, transferable development rights. My lord, there were some disputes, my lord. Matter now goes to, my lord, arbitration. In the arbitration, the, my lord, arbitrator holds that they had no right to relinquish any part of the property on my behalf to the BBMP, and therefore such relinquishment is bad. That is the finding which is recorded in the arbitration. My lord, they challenge it under 34 of the Arbitration Act, my lord, it is confirmed. Now, my lord, that relinquishment deed is executed in favor of BBMP. This suit is against BBMP. So therefore, my lord, when there was no power for them to have executed this relinquishment deed.
Representing BBMP.
No, he is not representing BBMP. He is, my lord, representing other party. He has lost in the arbitration. He has lost in the 34 petition. My land, my lord, he goes and relinquishes, takes benefit somewhere else. So therefore, my lord, this dispute was.
But whatever it is, what you sought is a simple injunction.
True, my lord.
Nothing else is, after in 2017, now the issues are framed basing on your pleadings.
True, my
for
lord.
a suit for injunction.
True, my lord.
These reliefs.
My lord, all these reliefs, because, my lord, arbitration had commenced. My lord, arbitration had not commenced. My lord, 2010, arbitration had not commenced. The release date had been executed, my lord, in 2000.
Was the order passed in the arbitration?
My lord, 2016.
2000?
Proceeding was initiated into the.
So 28th January 2016.
Is the 2021-16 is the arbitral
Yes,
order.
2017, my lord, we filed this application.
It on 2017.
Yes, ma'am.
11. That is after nearly 2 years.
Yes, my lord. There is some delay, but my lord, trial has not commenced. My lord, my dispute is against BBMP, not against him. BBMP does not have any, my lord, dispute about this amendment being allowed.
What is your, let's see what.
My lord, I am the owner.
There is the plain.
Yes, my lord, I am the owner. And my lord, mischief is created by the petitioner. who is
Let's
a-
see. Let's
Yes,
see
my
the
lord,
plain.
please see, the plaint, my lord, is at page 17. My lord, the defendants 1 to, my lord, 9 are all officials of the BBMP. My entire,
Where is he?
he is, my lord, 9th defendant. My lord, my grievance is essentially against BBMP. My lord, please see, the basic foundation facts are already there in the plaint. Please see.
A judgment and decree against defendant number 1 to 8, 10 to 11.
Yes, my lord.
Their agent, servant, so and so, for meddling with or dealing with the property.
Yes, my lord. No relief is as against
What is
him.
against you? Why are
Yes,
you
my
worried
lord.
about this?
Yes, my lord. Even-
That there was injunction, my lord, that is an injunction that we with respect to other defendants. My lord, the relief, know what is been sought is time bound, my lord.
Let us see.
My lord, kindly come to the plain government, my lord.
No. Now the reliefs, no, just now we saw 37 or what is it?
Amendment.
Yes, my lord. Amendment application is at page number 44, my lord.
And the plain know what. Page number 45.
Declare that all acts by defendants pursuant to the fraudulent relinquishment deed, including the issuance of the dated, is non-est in the eye of law. Directing the defendants to restore the scheduled property to the same state ante it existed prior to the formation of roads by way of mandatory injunction. Alternatively, direct the first to 8 defendants mandatory injunction to pay compensation. Direct by way of mandatory injunction to issue transferable development rights. No, all that you're seeking would directly affect him.
No, my lord. He is only the, my lord, he is only the developer. My lord, project does not come. I'll just pass.
No, just tell the court, this prayer of yours, directing the defendants to restore the scheduled property to the same state.
Yes, my lord.
Status quo ante. If status quo ante, what will happen?
My lord, whatever portion is relinquished to the road and given to the BBMP will come back to me. My lord, the admitted facts are not even a blade of grass was cut, not even.
Who has given that TDR?
Pardon?
This defendant.
My lord, he is my power of attorney holder. He was, my lord, initially the developer. My lord, he takes a joint development agreement from me, does not develop the property at all. My lord, he relinquishes without there being a specific provision either in the joint development agreement or in the GPA, he relinquishes a portion of my property saying you please take it for road, gets TDR certificate allotted in his favor, and my lord does not develop the property.
Don't ask any relief against him.
My lord, I have got the relief before the arbitration because I had an arbitration
That's what I'm
agreement.
saying, in the suit, original suit, no
Yes,
relief is sought against
My
him.
lord, because we are covered by arbitration, my lord, I could not have asked for any relief in the suit because, my lord, we are covered by arbitration. Arbitration, my lord, is ultimately held in my favor. Please have a look at this arbitration.
That could be. You
Yes,
can
my lord, but
document
yes, my
all
lord.
this.
This BBMP is not a party, my lord. There is no arbitration agreement with BBMP. Now, what the arbitral tribunal finds is all the acts which are done by him in relinquishing the property is illegal beyond the terms of the contract. That is the award passed by, my lord, the learned arbitrator, confirmed, my lord, by 34 court. Now that is inter se disputes between us is resolved. Now, my lord, the effect of that is, my lord, there is a relinquishment deed in favor of BBMP. Now, BBMP, my lord, will not be bound by what happens between us.
He's arrayed as,
Pardon, my lord?
he's arrayed as respondent number 1
Where, my lord?
in the arbitration.
Arbitration, my lord, yes. He is the claimant. He goes to the court.
He has raised the arbitral.
He has raised the arbitration saying that he should be specifically permitted to perform in terms of the joint development agreement. And all acts that are done by him are valid and correct. That has been turned down by the arbitration tribunal. And, my lord, just have a look at it.
Is that appeal is filed?
Appeal is filed, rejected. Appeal is filed, rejected.
Oh, in the civil court, none of those issues will be decided by the.
None of those issues will be decided. None of those issues will be decided.
Now you're seeking a relief
Against BBMP because.
Pursuant to the arbitral award, what is.
Yes,
passed,
exactly,
what
my
is
lord. Because the question is whether he had the right to execute a relinquishment deed on my behalf.
How are you affected by this?
Yes, my lord.
Now, what are all the rights that he's claiming? Or what are the inter se disputes between you and the defendant are decided by the arbitral tribunal? The arbitrator has decided and it has attained finality. Now, what is the difference that's going to make if it is this?
This property, the petitioner herein has developed the adjacent lands also, my lord. Why this area of land is being formed as a road? That is also, my lord, kindly come to para 52 of page number 2, para 13 of my objections, my lord, to the amendment application. Para 13, my lord. It is submitted that the suit was converted from agriculture to non-agricultural status by the conversion number dash. It is important to mention the cost of conversion was incurred by this defendant. There is no fraud attempt by this defendant. In fact, the Honorable High Court in WP 14879 of 18 of 2014 dated 30th and directed the BBMP.
No, that's on the merits of the matter. Court will decide that.
No, but once they asked to restore it, I cannot restore it because already the land is developed.
You will contest it.
My lord, one of the most
The
important.
the prayer, which is not practically possible, no direction can be given, court will not. No, it is like this. Amendment, what are the merits of the amendment? Whether that such a relief can be granted by that amendment, that we will not go into at the time of deciding the application. But whether that application can be allowed, on what grounds it should be allowed or dismissed is a question. What you are submitting is on the merits of the matter.
No, my lord, I'm submitting mainly barber limitation.
That will be decided by the court if it is.
How it is barber limitation? My lord, I just.
No, what will happen? No, please understand. That relief, if it is barred by limitation, he cannot have it. Court will decide it.
Going on to request of our Supreme Court, my lord, kindly see the two.
No, by way of an amendment, time barred reliefs cannot be granted. That is settled.
No, denying into judgments where when he is delayed, intentionally delays things, he is not entitled to seek for amendment. Because 2010 is a relinquishment deed, my lord. As on the day of filing the suit, he was aware about the relinquishment date. Suit is filed in 2011. Amendment application is filed in 2017. As per Article 58 of Limitation Act, he was supposed to challenge that relinquishment date within 3 years from the date of expiry or from the date of knowledge. Kindly see the plain term. Entire plain ordinance is about the relinquishment date. In 2011, he states about the relinquishment date. He tells there is no authority for me to execute the relinquishment date, but he doesn't challenge the relinquishment date. Kindly see the plain term.
Declare that all acts by defendant pursuant to the fraudulent relinquishment deed dated, including the issuance of 3 Heir certificates, is honest in the eye of law.
Kindly come to paragraph 21 of the plain. Sorry, page number 21, paragraph number 4 of the plain.
No, then when it's your case that it's a fraudulent deed.
Yes, my
Or
lord.
12/1/2020 as on the date of filing of the suit.
True, my lord.
Why did you not ask?
My lord,
for
now
it?
the question was whether, my lord, he could have executed it or not, which is why I'm just, my lord. Question is, my lord, if I had executed in favor of BBMP, my lord, it would be in a litigation between B and BBMP.
Then even otherwise also.
Even
you can-
otherwise, my lord.
you-
Therefore, that question is answered in the arbitration. May I just, my lord, give
That-
the arbitration award?
2011 is the arbitration.
Yes, my lord. It commenced, my lord, in 2012. My lord, notices were exchanged. Ultimately, my lord, it commenced in 2014. Now, please have a look at, my lord, issue number 3 in this, my lord.
Where will you get the issues?
Issues, my lords, will get.
3 is whether the respondent prove that the claimant is not entitled to relinquish the property.
Yes, my lord.
Under the
Please, my
joint
lord.
development
Please,
agreement
my lord,
dated
please.
17/1/2007
Please.
and amended joint agreement dated so and so and power of attorney dated and a special power of attorney. And this is held against you.
He held against him. Therefore, my lord, consequential.
Our pieces is dismissed.
No, section 34 petition is dismissed.
Ah.
As the preferred MFA, status must appeal.
When was it preferred?
My lord,
When was it preferred?
My lord, this last year. my lord.
last one.
Hmm.
I'm not on that, but it is filed, I am sure about that. The status must appeal is filed.
What is the number?
Number.
You are not a party to that.
No, no, no. The advocate, but client is a party.
What is the number?
Number. Just, Lord, give it.
Give
just
the
now.
court officer. List this writ petition along with the MFA number, so and so, as per the roster. Yes, next.
Till number 2,
And delete from parted. Yes.
till number 2,
I appear for the respondent.
Yes.
My lord, this is the petitioner's appeal, my lord, against the order passed in MA 8 of 2019.
Plaintiff's appeal, plaintiff's writ petition.
Please, my lord.
What happened? Injunction granted, not granted by the trial court?
The injun-
Writ petition by plaintiff's writ petition, my lord. Suit for declaration and permanent injunction. I under my lord 39 rule 1 and 2 came to be allowed in my favor.
MA reverse.
MA reversed.
What
Now,
happened before this court?
This court, my lord, on 19/9/90
2019, my lord, passed an order of status quo, which is still operating.
And date?
19/9/2019.
Yes, what do you say?
My lord, the petitioner prior to filing of the suit, my lord, had preferred a suit for permanent injunction, where that suit has been dismissed. Agreed by that order, my lord, they have preferred an appeal before the lower appellate court. My lord. The lower appellate court has confirmed the order of the trial court. That is, his suit for permanent injunction has been dismissed. So with respect to the possession, the said issue has already been determined. In such case, my lord, in the present suit, they have preferred the same relief and they have made an application under 39 Rule 1 and 2.
How can it be?
The said
when
application
the
is itself is
suit
not
for-
meeting.
when the suit for injunction itself is dismissed, appellate court has confirmed.
Lord,
With regard to your possession, where is the question of interim injunction? In a declaratory suit again?
No, my lord, that suit is different. This suit is different. This injunction is recurring, my lord. It's a recurring cause of action. It's
Recurring
not the
cause of
same cause of action. Now I have sought a declaration.
No, when you file a suit for injunction, when the court has dismissed, then what does
It was
it
on a
mean?
different footing, my lord.
On what footing?
Oh,
Court-
my
there
lord,
is a- There is a finding that you are in possession of the property.
I have in my own pleading stated, I have not suppressed the fact that I had filed a suit previously and filed this suit. In my pleadings, I have stated that.
Tell the court, forget about all that. You filed a suit for injunction. What is your case in the suit for injunction?
My lord, I don't know about that suit. I'll have
You
to.
have a copy of it?
Please, my lord, the findings has been recorded before the lower appellate court, my lord, at page number 51. Page number 51, my lord.
Yes. Where
The
is it?
page number 51,
Hmm.
paragraph 12. Plaintiff had filed OS 218/2006 against defendants and others for relief of permanent injunction in respect of suit scheduled property. And on context, this said suit was dismissed, holding that the plaintiffs have not proved boundaries of the suit scheduled property. And the said judgment was confirmed in RA by the first appellate court. In the judgment of OS 218/2006 at page number 10, the trial court has made reference to Exhibit D4, saying that it discloses existence of Karab land in between Taraka Channel and land of survey number 90. And also the reference is made in the same para that DW2 had admitted in his cross-examination that his father was buried at the Karab land situated towards survey number 90 of Hirahalli village. In the circumstances, there is no prima facie material to show towards southern side of the survey number 90 Taraka channel is existing. My lord, in this present suit, my lord, the dispute is relating to the boundaries. I am admitting that he is the owner of survey number 95, measuring 6 acres, 4 guntas. However, my lord, they have wrongly mentioned the boundaries covering the 20 guntas of land which is reserved for the cremation purpose. And the covering that, my lord,
Who are you representing whom?
defendant number 5 and
Who is
6, my lord.
defendant number 5?
I'm the public, my lord. I'm the public. So they have covered it, my lord. They in the boundaries itself, they have covered it. Previously, my lord, the suit has been dismissed, saying that they have not put the boundaries.
It says status quo. So what is happening in status quo? So nobody is using it.
Allah, it would be a problem, my lord. They don't have the right at all, my lord. Please, please.
Court says
Status quo, please, my lord.
So no, there is nobody that is not used as used for the purpose for which it is used. Burial ground.
Please, my lord, please.
Is it?
My lord, why while issuing the
I'm asking you, what is the implication of the status quo order?
status quo order, my lord, they are not supposed to enter that property if they are not in the possession of that 20 guntas of land. If the status quo is granted.
We have having the instruction.
Please, madam.
Status quo order is passed. What
Please.
is happening? But that particular land.
That I will have to verify, my lord.
Please get instructions on
Please,
that.
please.
We'll pass order.
Lord, that the dispute is only in
Day after?
respect of.
Day after?
Day after tomorrow.
This is not a day after tomorrow.
My lord, for the past 5 years, status quo.
Maybe, but under the circumstances, no. Maybe at the request of learned counsel for the respondent, this is matter day after tomorrow.
Lord, my
And by
request
that
on-
time, we shall get specific instructions.
My request on Monday, my lord, please, not Thursday.
Friday?
My lord, next week, my lord.
Next week, any day.
Next week, it won't, it's not possible. This is matter on 12th of March.
Please.
Interim order earlier granted, yes, extended till then. Yes,
That's okay.
Bill number 3.
please adjourn. No? It's not adjourned?
Bill number 3.
Do that,
Babu M for petitioner.
do that. There was no representation on behalf of both the parties. And also, the order passed by this court is not complied with. This court has directed the matters to be listed on the caption for dismissal. Today, the matter is called, there is no representation on behalf of both the parties. Accordingly, the petition is dismissed for non-prosecution.
Cell number
Please.
four.
Appeal for petitioner, my lord.
Not four, it is four? You filed the retirement memo? When the notices are served? The counsel for the petitioner has filed a memo for retirement wherein he has served the notices, send the notices on to all the petitioners, and the same is delivered on them. Even the track consignment is placed before this court. Accordingly, the petition is permitted to, the counsel for the petitioner is permitted to retire from the case in the name of the parties. This is matter on 18th of March.
Cell number five. Hearing.
Appeal for petitioner, my lord. My lord, I was supposed to, my lord, submit a translated copy of Mr. C, my lord. My colleague is there, my lord.
It's not.
I left tomorrow, my lord, kind of.
You have an interim order.
My lord, interim order is there.
This is matter on 21st of March. Interim order early granted is extended till then. Delete from a cap. Same. It's. If he is not there, a new stenographer has come. Kamala is given.